Good evening. Welcome, October 16th, 2025 Board of Adjustment meeting. Can you please do roll call?
Yes, sir. Mr. Carter? Mr. Gallo?
Here.
Mr. Jones?
Here.
Ms. Hudson?
Here.
Ms. Denny?
Here.
Mr. Cusick?
Here.
Thank you. That's 6 present.
Thank you. With 6 present, we have a quorum. Introduction of staff, please.
Good evening, everyone. My name is Jamie Fensky. I am one of the planners here for Kent County. To my left, we have Mark Kennedy, our IT staff for this evening. And to the far right, we have Fred Townsend, our legal counsel.
Thank you. At this time, everyone please stand for the Pledge of Allegiance. Any additions or alterations to tonight's agenda?
Yes, sir. I am going to ask that items number 2 and number 3 be moved to after items 4 and 5. So the public hearing and the business meeting call to order will go immediately following the statement of council.
Thank you.
Can I have a vote on that, please?
Yes, everyone in favor,
Aye.
say aye.
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 Thank you.
Public hearing introduction.
So good evening, ladies and gentlemen. My name is Jamie Fensky, and I'll preside as the hearing officer for tonight's public hearing. This hearing is being conducted for the purpose of providing the citizens of the county an opportunity to present testimony on these applications and the appeal before the Kent County Board of Adjustment. Everyone will have an opportunity to speak. This will provide those who wish an opportunity to give their testimony. If there is a group of interested citizens in favor or opposed to any of the applications or appeal, they may wish to elect one spokesperson among them to present testimony to the board. There is an official recording of these proceedings being made. Therefore, we ask that only one person speak at a time and that they speak clearly. Furthermore, there should be no cross-examination of witnesses permitted during the public hearings, but the board can ask the applicant questions after any opposition if necessary. As a courtesy to other participants in this hearing, a maximum of 5 minutes will be allotted to any person who wishes to provide testimony. The chairperson of the board has the discretion to allow additional time if deemed to be necessary. To make statements when your application is called, and for the record, please give your name, address, and allow our attorney to swear you in prior to providing testimony. Copies of any written statements or exhibits used during the hearing should be presented for identification so that they may be included in the permanent record. The procedure on the variance application will be as follows. The legal notice will be read on the case prior to the receipt of testimony. There will be a brief explanation of the application by the staff. The board will then receive testimony from all of those in favor of the application, followed by testimony of those who may be opposed. Once those persons in favor and those in opposition have had an opportunity to speak, the hearing on that application will be declared closed. Decisions on all applications heard this evening will be made by the board during the business meeting following the public hearing. However, you are not required to remain after the public hearing once your request has been heard and closed. During the business meeting, the board will consider all information of record. A common vote of 4 members of the board shall be required to make a decision on each application. If you do not wish to wait for the business meeting later this evening, you may call the Kent County Planning Department tomorrow between 8 a.m. and 5 p.m. at 744-2471. All applicants will receive written notification of the board's decision. This notice may not be mailed until after the next scheduled meeting, but if approved, you are welcome to apply for any necessary permits prior to receiving this by mail. Please keep this decision in your records for both you and all future property owners. The public notice of this evening's hearing was published on September 28, 2025 in the Delaware State News. In addition, all of the subject properties were posted with a sign prior to the hearing to further notify the public of the nature of the applications. Thank you.
Thank you, Jamie. At this time, we'll have statement by council.
Thank you, Mr. Cusick. The first of our 2 agenda items is a variance application, and the considerations for the granting of area variances were established by the Delaware Supreme Court in the case known as Board of Adjustment versus Quick Check Realty. The standards applied ask whether a literal interpretation of zoning regulations result in exceptional practical difficulties of ownership. In order to determine whether the exceptional practical difficulty test is met, the board must weigh the following 4 factors. First, the nature of the zone where the property lies. Second, the character and uses of the immediate vicinity. Third, whether removal of the restriction on the applicant's property would seriously affect neighboring properties. And fourth, whether failure to remove the restrictions would create exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This factor satisfied only when the difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. Note that the inability to improve one's business or stay competitive as a result of area limitations may qualify as a legitimate exceptional practical difficulty, and it's here where the board considers whether the applicant is seeking more than is minimally necessary to relieve the asserted difficulty. In general, the board's not permitted to consider factors other than the 4 I listed, so those speaking both in support of and in opposition to applications are urged to present only information bearing directly on the 4 factors, which restated briefly are 1, the zoning district, 2, the character of the immediate vicinity, 3, the effect on neighboring properties, and 4, whether the applicant faces exceptional practical difficulties of ownership. In particular, presenters are instructed to exclude from their presentations, and this part applies perhaps to both hearings, discussions of personal disputes and acrimony between the applicant and neighboring properties. Presenters must limit their remarks to the issues the board can decide. That concludes my statement, Mr. Cusick.
Thank you, Mr. Townsend. At this time, we'll begin the public hearing for application A25-28.
Okay, so we have application A-25-28 for Burke & Burke Properties, LLC. Present zoning district is BG, general business. The proposed variance is a variance from the requirement that a wall mount sign be no larger than 10% of the area of the building front which the business occupies. Present use is motor vehicle sale and repair. Proposed use is same with the sign. Levy Court District 4th for Mr. Scott. Located on the northwest corner of Old Beach Road and Bountiful Lane, north of Frederica. Here you will see the proposed sign that they are seeking. The total size of the building front is 1,162.29 square feet. The permitted sign size of 10% would be 116.29 square feet. And the proposed sign is 168 square feet, which would be 14.5%. This is looking at the front of the building. Down the road, heading south. This is at the existing detached building that's there. This is the proposed location there on the roof of where the new sign will be going. And from the side, and the aerial. So Mr. Burke, if you would like to come forward, state your name and address, and allow our attorney to swear you in.
James Burke, 97 Wayne D. Avenue, Milford, Delaware.
Mr. Burke, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may proceed.
So how this situation all came about with the sign is we made the sign to go on the roof. And after we made the sign to go on the roof, we learned that in Kent County, you're not allowed to have a sign on the roof of a building. There was we couldn't do that. So we decided to appeal that, and then we took pictures of all the businesses down Route 13 with signs on the roof, and then we got a notice from the county that we could put a parapet wall on the roof. And by putting the parapet wall on the roof, we could put the sign on that. The sign, when we made the sign and designed the sign for the roof, we were well within the square footage that we needed for the roof. But now that we're calling it a parapet wall, they do the measurement of the front of the building and the measurement of the parapet wall, which gives us the percentage that we're only allowed to have. So the sign is just a little bit too big for what we're allowed to have. I have pictures of the sign on the roof before we took it down. It's very important for us to have this sign on the roof because we need people from all the way on the other side of Route 1, the northbound traffic, to see what's going on over there. And since the bypass and everything, we are far away from the highway. And I mean, that's where we're at with it.
Did you want to pass that picture around?
The whole situation with the parapet roof, the parapet wall and everything, we had to have a designer design that. We had to get an architectural stamp to do this parapet wall, which was $900 and some. So this has been a big expense by not being able to put the sign on the roof. But we were advised that it'd be easier to do this parapet wall than to appeal the issue of Kent County not having signs on the roof.
Any questions?
I have questions. So just to clarify your testimony, someone in the county told you that you could have the parapet, put it on the roof, and nobody said to you, but there are signs, like you had to have a permit to put up a sign, there's rules and regulations or codes for putting up signs. And here's one thing, I feel very strict about sign sizes. One of the big issues with signs for me is that we have, and this is not an issue for me, we have freedom of speech. And so we can't really govern what you put on that sign, but we can govern the size of it. Realistically, this is a lot bigger than we allow. And I think once we start giving variances to codes, most especially codes like the signs, I think sometimes we find ourselves in trouble down the road because what you have is lovely and it certainly defines your business, but if the sign's there and the permission's given, we can't control what the next person does and what will be seen from the highway. And there's some signs that recently went up on Route 13 on a building that when my grandchildren come out of Fast Landing Road onto 13, that it's in their face. And, you know, to me, it's inappropriate, but again, we don't really have control. So, other than you can't see it from 95, what is the hardship?
Well, the hardship is the sign was made size-wise for the roof. So when we were told we could put the parapet wall up, that seemed to be the answer to what we needed. But then we realized the sign is too big for the parapet wall for what we're allowed. It's already made, we've already paid for it, and it's either we put it up there or we throw it away. And our main thing is that building is in a ghost town as far as traffic on that road is dead. We need to get the people from the highway to see what's going on over there. And that, I mean, we needed the sign to be up there. We couldn't put the sign on the face of the building. You couldn't see it from the road.
You couldn't see it from Route 13 if it was on the face of the building?
If it was on the face of the building, no, ma'am. And the building's all glass in the front. So there was, under that porch on the wall, there's only like 2 feet of brick above the windows. You'd never see it from Route 1.
Okay, take aside the fact, the Route 1, seeing it from Route 1 aspect of this. And so, but you could see it from Route 13, and I'm assuming it's going to have some lights on it or something, at least at night if you're in operation.
There isn't a Route 13, it's just Route 1.
Or Route,
There's Old Beach Road, which
Old
is
Beach Road.
is an
Okay.
access road now, and there's no real
okay, the old
traffic.
Webb's Market, I get it now.
Right, there's no real traffic on that road other than people going to their houses or whatever, but the main traffic is Route 1. And we are a ways from Route 1 now.
And someone from the county told you, when they told you you could put the sign on the parapet on the roof, they didn't.
No, that was a mistake that I made. I didn't know you couldn't put a sign on the roof. And that, we went ahead and did it, and then we got a notice that sign has to come off the roof, and we took it down right away.
Okay.
Then we went through, let's appeal it and see if we can get it to where we can put it on the roof. And the county said, if we did a parapet wall, we could put the brackets that are up there that were for the sign, we could close that in, and it would then be a wall. And we could put the sign up there, but the issue that we're having, that we're here for tonight, is we're not a lot bigger than what we're allowed. We're, I think, 14% or something like that from what it's allowed to have.
It's bigger. It's bigger than you're allowed. And so, and what I'm trying to ascertain with my questioning is, did somebody from the county office, the planning office, the permit office, suggest to you or tell you that you could have a sign larger than what our code allows?
No, they suggested I come here and ask for a variance on it. Because the girl at the county was really good. She spent a lot of time with us trying to figure out how we could cut that down without just throwing it away. And it just came to, let's go for a variance on it, because we're not asking for a whole lot.
Okay.
I have a question. From a marketing standpoint, what percentage, if you could give a percentage roughly, do you expect of your business traffic to be produced from that sign?
All of it off of Route 1. I mean, on Old Beach Road, we don't expect to get a lot of business off Old Beach Road. We expect, I would say, 75 or 80% of the business to come off Route 1. And just working on the building, we get people that come around to see what's going on off Route 1. It's quite the job to get there from Route 1 also.
As far as people who don't know about your business and driving by, how much do you expect to be pulled in from that sign?
Quite a bit.
Can you give me a rough number? I'm not going to hold you to exact amount, just.
From people seeing the sign and coming back, motorcycle people.
Correct.
75, 80% of the people that see the sign will come back for it.
Thank you.
Is this all one sign, or is it 3 separate pieces?
The panels are 3 panels all put together. It's a.
So is it the number 1 on each side, is that separate?
That's separate panels that go on there, and the panel, the other panel is behind that. That one is on top of the other panel.
So if you get rid of one of the ones, what's that?
We still didn't come down to where we needed to be.
Right, but it gets us a little bit closer.
Right.
Any thought on that? Is that negotiable, or you?
Yeah, I mean, that is the design. We'd like to have that design because it's evened out. And at this point, it's a big waste if we don't use it. There's no other purpose for it.
Is there other signage out there in front of the building?
there's just the small podium sign that you had in the picture going the other way, that sign there, and that's really useless from Route 1.
So your testimony is that if we were to decide to meet you halfway and remove one of the ones with the face on it, skeleton, you wouldn't be interested in doing the sign?
I think it takes away from our logo. By taking one of them away, it takes away from it just takes away from the whole logo.
Here's my, what I often say. For years, we have a comprehensive plan. It changes from time to time to keep up with things, and along with that is our county code. And as far as I'm concerned, and I hold a position on as a Board of Adjustment Commissioner here, and I also hold a position in the planning aspect for the city of Dover. And I take the code seriously. It's not written in stone like the Ten Commandments, but it's the guidelines that was long thought out, voted on, and it was developed and voted on to be our code. And so when you come before us to change that code, to vary from that code, to get a variance, there's supposed to be an exceptional practical difficulty, a reality. Sometimes people will come and say, well, if I have to meet these setbacks, then my land, you can't put anything on my land. That's an issue that, you know, is an exceptional practical difficulty. Or the whole back 40 is wetlands. And so sometimes you have to give variances. But, you know, it'll cost me, or this is what I want, doesn't fit for me, my idea of a reason to vary from the code. And I'm just trying to explain that so you get an idea of what I'm thinking.
Yeah.
And that's me.
Right.
There's a lot of other
I
board members
understand.
here.
I understand your theory on that. And if Old Beach Road was Old Beach Road, then I wouldn't be asking for a sign that big. But that piece of property, where it sits now, with Route 1 moved over, it's very important for us, for that sign to be that size to be seen. Because if that piece of property there on Old Beach Road, if you never had traffic from Route 1, you might as well close it up, because you're not going to get any kind of business in there. We have to get the people from Route 1 to see what's going on over there, and to go all the way up to the next exit, get off, and come all the way back down to it. So we feel that sign is very important to the success of that business making it.
Do you do any other advertising at all?
I used to own Extreme Graphics in Milford, so I used to do a lot of it.
Like advertising in papers and
Oh, for this?
media and yeah.
We're not open
No.
yet. We're not open yet.
Any other questions?
Could the staff just cycle through the pictures of the location one more time for me, please? Where will the parapet wall sit if
Right where that
granted?
frame is. What they're having us do is take that frame and close it in and call it a wall now.
I understand. Thank you.
May I? Sir, you owned Extreme Graphics, is that right?
I used to,
Do-
yes.
Do you make signs?
I used to.
Did you make that?
Yeah, I did.
You made this sign that we're talking about right now?
Yes.
So you didn't have the benefit of anyone's expertise in determining whether the sign size would be compliant with your,
Well, we were going on Sussex County. I didn't know that you couldn't have a sign on the roof in Kent County. And then after going down Kent County and taking pictures of all the signs on Route 13 in Kent County, I just couldn't believe that that wasn't allowed.
so the cost of adjusting a sign or making the sign was lesser in your case than it would be for somebody who doesn't have your skills, I presume.
Well, I don't own the business now, so it's going to be, to change that sign, it'd be quite a bit more.
But did you make the sign?
I did. I made it when I had the business.
Okay, how about the other sign that's there currently? Is it as large as it's permitted to be, or is it smaller? That one?
That one there, that's been there forever. That was Webb's Market sign. It's just refaced. That was the sign that Webb's Market had.
So you don't know whether that's as large a sign as you're permitted in that spot?
It's, it's there. It was permitted at some point, I'm sure.
I have to say it's kind of hard to read.
That one? You can't read it at all. Not from Route 1. And it's seen.
But I mean, I can't read it from here. I mean, it's, the script is blurry. Or it's not but well defined. Anyway. Did you make that sign?
I did.
So what would it cost to remove one of the panels or both of the panels with the numerals and skulls on them?
On the top of the building?
The sign you want,
Yeah, probably $3,500.
to remove them?
To redesign it. It would have to be, if we can only have the square footage that is put out now, that sign has to be smaller. The only way to make it smaller is to make another one.
Well, that's not, I mean, that's what I was trying to get to, like, are the ones separate pieces?
They're separate pieces on top of the back piece. The blue collar cycles is aluminum all the way across.
Yep.
And then the ones are mounted on top of it. So you'd have to take the ones off and then cut the sign down behind it. But then the parapet wall is going to be there, because the parapet wall is already designed and we've got the permits and everything, that's all approved. You'll just have a wall there with nothing. The parapet wall that we're building is the same size as that sign. So making the sign smaller, you'll still have the wall behind it, which in our view, it makes no sense. If the wall's going to be there, you might as well have a sign on it.
With all the signs that you have made over the years in Kent County, some in Kent County, this is the first time you ever knew that we had regulations about the size of signs?
We've always had the customer do the permits. We've never done the permits before.
Wow.
Any other questions?
Is that an illuminated sign?
No.
Thank you. One more question. So at night, you won't be able to read that? There won't be any lights on it?
The parking lot lights are on it.
Okay, thank you.
Any other questions? I think we're good. Thank you.
Thank you.
Is there anyone else that would like to speak in favor of this application? Please state your name and address and allow our attorney to swear you in.
Robert Medding, 3697 Bay Road.
Mr. Medding, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, sir. Good evening, ladies and gentlemen. I would just like to say that Jim and his mentor to me and showing great business at Extreme Graphics and different things he's done and taken things and fixed them up as he's done at Extreme Graphics and moving up to Blue Collar. I've had great experience with Blue Collar when they're in Subbyville, and it would be a great addition to our area to have a reputable shop, great service, and I think it's a great idea. I don't know what the percentage is on the sign being a different size, but I think it would be all right. The 4 points that Mr. Townsend brought up, I think, are all addressed. The codes that were put in for signage size, I think, is a lot different years ago when we were riding 55 on Route 1, where everybody's running 80, 85, and I think the different size sign would definitely help with the direction to get to them safely as the new designs on Route 1. If you have any questions, I gladly answer them.
Any questions? I don't have any questions. I just wanted to point out to the members, we do have a letter from this application as well in support. I think it looks like a local business, JC Liquor Mart. Pretty much echoing the same thing, just more visibility off Route 1. Any questions? Good. Thank you.
Thank you for your time, folks.
Thank you. Is there anyone else that would like to speak in favor? Please state your name and address and allow our attorney to swear you in.
I'm Jeff Iverson, 2504 Jeb Road, Wyoming, Delaware. I just want to...
Sir, over here.
Oh, okay.
Sir, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I absolutely do. I just really want to speak on the character of Jim Burke, and this piece of property that he's improving is the old Webb's Market. That building was dilapidated, an eyesore, and he has polished that thing up. If you've ever seen Extreme Graphics in Milford, I mean, it was the best looking building on Route 1. And I know by looking at the pictures, Webb's Market has made an amazing turnaround since Jim bought it. And it's not going to be an eyesore. I don't think this sign, in my opinion, a couple feet over what he needs to have is a big issue. And he is in a area off of Route 1 that's very hard to see. And bypassing traffic on Route 1 will definitely see the sign that he's putting on that parapet wall. And my opinion is he's done a great job. The building's beautiful compared to what it was. If any of you all saw the Webb's Market before he bought it, I mean, it was an eyesore. I mean, it was probably close to being condemned. So look at it now. Thank you.
Thank you. Any questions?
My name's Stephen Baker, 22915 Deep Branch Road, Georgetown, Delaware.
Mr. Baker, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, sir. Ladies and gentlemen, I own Blue Collar Cycles. I opened this business in 2003 in Fenwick Island, Selbyville area. I opened with nothing, and I still got pretty much all of it, okay? But I have been open for 22 years. I did this on my own. I've been given the opportunity to open a second location here in Frederica. And like the last gentleman said, if you saw the before and after, I think it would blow your mind. I made a few points the last few days. Some food for thought, maybe some things to think about. The building's beautiful. I need a beautiful building because I do beautiful work inside it. I don't say that with arrogance. I say it with confidence. I've been open a very long time. I have a very busy business, and I think I can really add something to Kent County and the Frederick area. When I hear mention of logos and everything, I'd just like to make a small point about brand recognition, how important it is. Google brand recognition. It'll explode on the internet like a virus because every company that we know of thrives and goes to great lengths for brand recognition. That number one in that skull, that's my brand. If you notice here on my shirt, I came from work today straight here from Fenwick Island to here. I wanted to make sure I was on time. I didn't get to change. That's my brand. It's very important to have a big sign. And the reason I think that is when we talk about seeing the same logo over and over, I've got one shot. When someone's going 75 and they're on their phone going north or south on one, I've got one shot to draw them in. My one shot is a big, beautiful sign on top of that building. It's the only way they're going to see it. It's the only way I'm going to draw them in. And I may not get them when they're headed towards the beach, but maybe if they see that sign, they'll say, I want to stop and hit that on the ride home. Because the fact of the matter is, it is tough to find. You got to take some exits, you got to make some turns. The bypass, in essence, destroyed the road it was on. I plan on turning that around. I know I can do that. I don't need help running that business, I promise you that, because I've been doing it a long time, and I feel confident I can do it here just as well as I've done it there. What I do need help with is getting people to recognize that business, come in and give me a shot. That's what you can help me with. I need help from that sign, and I need your help to let me put it up. Maybe I was a little naive when we designed the sign and made it too big. I build engines, work on motorcycles for a living. I don't do signs, but I do know that a big sign is extremely important. And the reason I know that, and this is maybe not off topic, but it is the topic. Going to Florida when I was a kid, every 5 miles we saw south of the border signs. If you guys have been to Florida, now every 5 miles we see Bucky signs. They have the benefit of a sign every 5 miles. I've got one sign. I got to get them. I got to get them that one shot. I don't have the luxury of 10 more signs every 50 feet. I know those signs work because my kids tell me, Dad, can we go to Buc-ee's? Oh, absolutely, we can. And I want people's kids to say, hey, Dad, Mom, can we go to Blue Collar Cycles? Look how cool that sign is. That's what I need. It's drivers are distracted, to say the least. I need to distract them into Old Beach Road. That's what I need. And like I said, I don't have the luxury of billboards everywhere, and to put a sign underneath that awning, it would be totally lost. There's no way you could see that. Big red, white, and blue sign is, if I'm anything, I'm American, and I want a big, beautiful sign on top of that building. And I'm just asking for just a small ounce of consideration to help me make this business as successful here as I've made it in Fenwick Island. Let me put that sign up, and I'll do the rest. Thanks a lot. Appreciate your time.
Thank you. Any questions?
I'm glad to answer anything you'd like to know.
Good. No questions? All right. Good. Thank you.
Thank you.
You want to go first or me?
Name and address, please. You go first.
Philip W. Pennington, Senior Fire Chief of the Bowers Fire Company.
Sir, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, sir. I just wanted to come up here and be in support of these two gentlemen for this adventure that they're getting ready to ride on. And as far as the American dream, we're going to help you with that, because Bowers Fire Company, these two gentlemen right here were just at our event down to Bowers where it was the shrimp and crab feast. They were gold sponsors for us. And Mr. Burke there has been a very strong advocate for us as far as the fire service and supports us all the time. As far as that old sign that's up there, that gentleman did say that that was a sign that was from in the past, and things change. And that's no disrespect to you, ma'am, but things change just like the world's changing every minute. So I'm just here in support to help these gentlemen get that sign up. It's not an LED sign, and I find those more annoying than any. This one would be toned down quite a bit. So I'm in support of a sign there, and we need more business right there in Little Heaven. We've needed it for quite some time. We have a little Walmart now, which is the DG. That's been a big plus for us there in that little strip that we have. But I just wanted to be here for them guys and hopefully for this county to put another business in the Kent County. Any questions?
Very good. Any questions? Nope. Good. Thank you.
Thank you.
Is there anyone else that would like to speak in favor of this application? Anyone online?
We have no members of the general public online at this time.
Thank you. Is there anyone that would like to speak in opposition of this application? Seeing no one, we will close the public hearing for application A-25-28.
Thank you. So I'll close the public hearing. We'll move on to the business meeting. So we need approval of the business minutes from August 21st, 2025.
I will make a motion to approve the business minutes from October.
I'm sorry, September 18th.
From September, from last month's meeting, from September 2025.
I'll second.
We have a motion and a second. All in favor?
Aye.
Aye.
Approval of the notice of decisions from the September 18th, 2025 meeting. It's application A25-27 and A25-26.
I will make a motion for approval of the notice of decisions from last month's meeting, and those are A25-0.
27. 25, 26. 25, 26, 25, 27.
A25-26 and A25-27.
Second.
We have a motion and a second. All in favor?
Aye.
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 No old business. We'll do deliberation on application A25-28, Burke and Burke.
Okay, so again, this is a variance from the requirement that a wall mount sign be no larger than 10% of the area of the building front which the business occupies. The size of the building is 1,162 square feet. The permitted sign size would be 1,116.29 square feet, and the proposed sign is 168 square feet, which would be 14.5%.
Thank you. Motion or any discussion?
I have a question for staff. When we're counting the size of the building, like the front of the building, are we merely counting just the front of the building, not the roof, or do we count the roof as well?
It would just be the wall. So it's all of this along the front here, and then the parapet wall, not the roof.
So to follow up on Morgan's question, the percentages are based off of the wall because your ordinance states that it's a wall. You needed to have a wall sign, right?
Correct.
So given the fact that the roof actually has a longer span than what the wall does, obviously because of the overhangs, that didn't move, those percentages didn't move. We're still basing off of the wall.
Correct, just off the wall and the parapet wall.
So he's 95.5% legit, and he's only over by 4.5%, correct?
Correct. He's allowed 10%. He's asking you for 14.5.
Which is 4.5% over.
Yes.
Could he make the wall, the parabon wall, like bigger, or is it limited to just that size?
No, if he made it bigger, we could use that and count 10% of that bigger wall.
So, for starters, the staff report recommends denial. You know, we have to be really careful about setting precedents. And I understand what he's saying, but I still think perhaps we could, you know, eliminate, like as Brian suggested originally, like maybe the ones or one of the ones at least, and at least be met halfway. I mean, sometimes, and you know this because I say it from time to time, we get up here and it's like the county code is a book of suggestions. It's our code.
I just want to double check. So if he makes his wall bigger, he wouldn't need a variance.
No, I'm not saying that.
Oh.
So it would still be counted towards the square footage of the wall. So for example, if he made that 100 square feet larger than what it is now, that would gain him 10 more square feet for the sign.
Based on the photo that he provided, that sign looks in proportion to that roof. It doesn't look exceptionally large. That building sits a little bit lower than the road bed as well. And probably not, people are probably not. I mean, probably not on Friday. In the summer, people are probably not driving at 75. But for the most part, if you're driving on the highway, you're going to need a larger sign just to be able to catch your eye. And the testimony was that he is depending on that drive-in business and to attract people to come. So based on the photo that they have there, I mean, the sign looks in proportion to the building. That roof is much larger. It's not blocking anybody's sight behind them.
Excuse me, it's our code. Our code doesn't say, well, whatever you think. Our code is not a book of suggestions. It's our code. And if we were here to decide about granting a variance based on hardship, and frankly, I don't see a hardship in bringing it down and possibly meeting us halfway. That's what I'm suggesting.
Well, aside from the aesthetics of it, the building sits, I believe, a little bit lower than the roadbed, which makes it unusual for a storefront. Usually a storefront's on a street, and you're walking past it, you're driving past it, it's at eye level. This is lower than the road, and that's what he's looking to attract. There's not that much other traffic going by there. So I think it is a hardship. They have the sign. They have set up the parapet. But even though that was by their own choice, the location itself lends itself to maybe giving a variance on that sign.
I agree.
Make a motion to grant the variance on the proposed sign of 168 square feet. I believe there would be an exceptional practical difficulty for the applicant if the variance is not granted, given the location and the setting on the highway.
Second.
Got a motion and a second?
Thank you. Mr. Jones?
I'll vote in support of the variance for application A-25-28 based on this testimony tonight and based on the photographs and the length of the roof compared to the frontage of the actual building. I could see that if it was just the front of the building to where the sign may not get this variance, but given that length of that roof, I do vote in favor of the applicant.
Thank you. Mr. Carter?
I'll vote in favor of the motion based on the testimony tonight. I don't believe that this will create any hardship on the local community.
Thank you. Ms. Hudson?
I vote in favor for A-25-28. Based off the public testimony that we heard tonight, I believe removing the restriction does not cause serious harm to neighboring properties. I also believe there is a hardship being there on a smaller road with small businesses trying to stay competitive for the area and to draw in new businesses. And I believe there is a financial hardship on the owners by having to remove 0.45% of their sign down. And I believe that the roof is so large that it wouldn't be an eyesore to the neighboring properties.
Thank you. Ms. Denny?
I vote no. Based on the testimony given this evening by the person who designed and put the sign up, they have had experience with the sign and the code, signing restrictions and codes in Kent County. And I do think if we were able to meet them halfway, possibly, I might agree to that. But I've always been pretty strict on our sign code, so no.
Thank you. Mr. Gallo?
I vote in favor of my motion for the reasons stated.
Thank you. And Mr. Cusick?
I vote yes to the motion. I don't think this will affect the neighboring properties as well as the hardship there to stay competitive, this business to stay competitive in that area. Per the testimony given tonight, they're drawing 75 to 80% from Route 1. So 4.5% larger sign's not gonna, is a minimal impact.
Thank you. That's 5 in favor, 1 opposed of the motion.
With 5 in favor, application A, what is this number? A-25-28 is approved. Does anyone need a quick break or we keep rolling? Good. Temple, you good? Temple, you good? So that concludes the business meeting. We'll hear the appeal.
So the appeal is for application A-25-25 for Donna and Jeffrey Brennan. The present zoning district is AC. The proposed appeal is an appeal of an administrative decision pursuant to Section 205-399 regarding the determination that the subject property is not considered a farm under Section 205-54 of the Kent County Code. It's in Levy Court District 6 for Mr. Hertz. It's located on the southeast corner of Jeb Road and Dogleg Drive, west of Camden. This is the front of the property. Looking down Jeb Road. This is looking from Dogleg Drive. and the aerial. Mr. Pardee, I believe you are going first.
If I could, very quickly, as you're setting up, just remind the board that the board does have authority and jurisdiction to hear this appeal. Pursuant to the zoning code, the board has the power to hear and decide appeals where it's alleged there's an error in any order, requirement, decision, or determination made by an administrative official in the administration of the zoning ordinance for Kent County. In the course of exercising that authority, the board may adopt, reject, or alter the decision that has been made in accordance with its judgment, as if it was standing in the shoes of the official who made that determination. Any questions about that? It's not the first appeal that you've heard, but as a reminder, it is a separate set of circumstances and considerations than we hear in the case of variance requests.
Mr. Chairman and members of the board and staff, good evening. My name is John Pardee. I'm an attorney with the law firm Brockstedt Mandalis Federico here in Dover, and I represent the Brennan family, who are the appellants before you tonight. What we'd like to do is have the two Brennan sons speak to you first to tell you a little bit about what they're doing at the property. Then I have a PowerPoint to run through, and after that, we'll hear from Mrs. Brennan, the mother of the two boys who are operating a chicken coop at the property. So without further ado, I'll ask Connor and Jeffrey to come forward.
And we'll start with name and address for the record, and then I will administer the oath.
Thank you. My name is Jeffrey Brennan Jr. I live at 2442 Jeb Road.
Mr. Brennan, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
You may proceed.
Agriculture has been the backbone of my life ever since I learned the definition of it in my 6th grade extracurricular club. Agriculture has driven my current and future goals, accomplishments, and career path. I am currently a student at University of Delaware in the College of Agriculture and Natural Resources. I plan on completing the 4+1 program to get my master's and go into education, teaching agriculture to low-income school districts. This year, I also plan to achieve the high honor in my National FFA degree for my SAE in personal poultry. After I graduate with my master's, I plan on using the poultry that I have readily available to me to give my future students a better hands-on experience with the livestock I'm teaching them about. These birds not only taught me and my brother, but also will allow me to teach the future generations of farmers, vets, food scientists, and so many more future leaders in the development of agriculture. Thank you.
Anyone have any questions?
Are these your birds?
They're all of ours.
Okay. How long
So
have you guys
it's-
been doing it?
How long? So it started back in, I think, not 6th or 7th, about when I got into high school. So 9th or 10th grade, we started getting birds. I specifically was the one who was taking care of them. Now that I'm away at college, Connor has taken up more of the protocol with feeding, watering, taking care of. And we enter them in the state fair to do like poultry showmanship and just show them off.
Yeah.
Okay, so you said since 9th or 10th grade, but could you give us a date? A rough estimation of how many years this has been going on?
4 or 5.
Thank you. I mean, I'm anticipating there are going to be a lot of questions about the nature of the operation during the course of the meeting, and I presume you're going to be in position to answer a fair number of them, Mr. Pardee?
Yes, and if I can't, I can ask my clients to step forward.
Just step back up. Okay.
Sure, they'll be available. So next we'll hear from Connor.
Name and address for the record.
Connor Brennan, 2442 Jeb Road.
Connor Brennan, is that right?
Yes.
Do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, sir. I'm currently a student at CR High School, class of 2027, with a vision for my future, and I intend to take advantage of the tech and the SEED program and attend Del Tech and the University of Delaware, majoring in ag business and an ultimate aspiring to my own and operation of successful poultry facility, thereby contributing positive to the local agriculture. By building connections with Dell's auctions, I am getting invaluable hands-on experience and insights that are accessible for running a thriving agriculture business. Following in my brother's footsteps, I am diligent, working towards earning my state FFA degree before graduating, reflecting my dedication to my excellence in this field. Every day I maintain the chicken coops. I am developing necessary skills that it will benefit my future career and as an about learning experience that come with hatching and raising chickens. All of this increase my drive towards my ambition. My strong determination to become more involved in agriculture in Delaware begins with my responsible at home, and I am committed to nurturing that passion.
Thank you.
Thank you, Jeffrey and Connor. So I was going to do this later, but I might as well do it now. I have some letters that I'd like to submit for the record from the boys' teachers, which explain a little bit more about the programs that they're in. This is, I said chicken coop, it's poultry husbandry. And they're both studying, this is what they want to do. They're both involved in Future Farmers, and this is what they want to do for the rest of their lives. So I have some letters from their teachers, which I'll hand forward. Okay, so while Jamie's handing those out, I'll get started on the PowerPoint. So just by way of overview, I'm going to talk a little bit about the property, show you some pictures, and kind of explain what happens at the property. We'll also talk about backyard flocks, which are a very common agricultural use in Kent County. Our primary argument is that the county has no legal authority to restrict agricultural uses on AC zone properties, and that's pursuant to the Delaware Constitution, which we'll talk about. And lastly, the planning department's determination in this particular case, we contend respectfully, is unlawful and discriminatory. So by overview, the property is located at 2442 Jeb Road, south of Westville Road, west of Almshouse, about 2.5 miles west of the town of Wyoming. And as we pan out, you can see that the property is not located within a residential subdivision, but rather is located in a rural area of Kent County, which is in level 4 outside of the growth zone. The property is approximately 1.15 acres in size, and critically, this is extremely important for tonight, it is zoned AC Agricultural Conservation. Under Section 20553B of the County Code, agriculture is a first permitted use of the subject property. Section 205-54 of the County Code defines agriculture as these uses include crop production and animal production. These uses also include any other agricultural use recognized by Delaware law. Animal production, which your code says is a first permitted use in the AC zoning district, is exactly what the Brennan Boys are doing at the subject property. These are obviously chicken hatchlings, turkeys, some pictures of the turkeys and chickens, and they harvest and sell eggs from these birds. So, backyard flocks, that's what this is. You're looking at a backyard flock. Very common and lawful use of property in the AC zoning district throughout Kent County. And what the Brennan Boys are doing is no different than what numerous other property owners are lawfully doing throughout the county. A backyard flock has to be registered with the Delaware Department of Agriculture in order to sell poultry or eggs or exhibit birds at any show or fair, like the Harrington Fair. If you want to take chickens or turkeys to the Harrington Fair, you have to have a flock registered with the Department of Agriculture for good reasons. You know, they want to make sure the birds are healthy and don't have any disease problems and whatnot. So the Brennan flock is in fact registered with the Delaware Department of Agriculture. Interesting, I didn't know this until this case came about. But there are 682 registered backyard flocks in Kent County. These statistics come from the Department of Agriculture. That's where I got this information. So the vast majority of backyard flocks, 585 of those 682, are located on a parcel of land which is smaller than 10 acres and which also features the property owner's primary residence. So if you drive around the western side of Kent County, you'll see these. I didn't know they were out there, but I spent a lot of time driving around, as you'll see from the pictures I'm going to show you. You can't go down a county road on the west side of Kent County without seeing a backyard flock. The 682 backyard flocks in Kent County range in population from 1 to 11,000 birds. The average number of birds per flock is 44. 47 of those flocks are being utilized for the purpose of selling eggs, and 254 flocks are mixed. They include some combination of waterfowl, turkeys, or game birds. Again, these are all statistics provided by the Delaware Department of Agriculture. As you heard me say, the use that the Brennan Boys are making at the property is no different than the agricultural uses being conducted on numerous neighboring properties. Here you see a chicken coop at 955 Jeb Road, just down the street. And importantly, if you look at the records of the county on the county website, this property is zoned AR, agricultural residential. It's 2.26 acres, and the property type says agricultural with residential. And you'll see, let me back up, I'm sorry. That's the primary residence, and that's their chicken coop. This is 10757 Westville Road. It's a primary residence with a chicken coop. You'll see this property is zoned RS1, single family residential. It's 2.8 acres. Property type, single family dwelling. This is 8617 Westville Road, zoned AC agricultural conservation, 2.44 acres. Single family dwelling. 8882 Westville Road. Single family dwelling, chicken coop in the backyard. This property is zoned AC, 2.51 acres, single family dwelling. 2186 Jeb Road. Zoned AC, 1 acre, single family dwelling with a chicken coop in the backyard. 2887 Pearson's Corner Road, zoned AR, 1.5 acres, chickens running free in the front yard. It's a residence, as you can see. 633 Foxhole Road, zoned AR, 3.1 acres, single family dwelling, chickens in the front yard. 91 Tobacco Road, zoned AR, 2.8 acres. It says mobile home, but as you can clearly see, there's a house, a very nice house, and on the side, rear yard, they have a chicken coop. 4271 Mud Mill Road, The county website doesn't list what the zoning of this property is, but it's next door to another property that is also zoned AC, 0.47 acres, single-family dwelling, chicken coop in the side yard. 1304 Calmarsh Creek Road, zoned AR, 1 acre, single-family dwelling, chickens in the backyard. 7921 Willow Grove Road. This property doesn't have a zoning record on the county website, but I can tell you, and you can see from the pictures, it's out on the west end of Willow Grove Road in an area which I believe is zoned AC, chickens in the side yard. 9517 Willow Grove Road. Zoned AR on 1/3 of an acre, a single-family dwelling with a chicken coop in the backyard. Now, interestingly enough, Kent County is a pretty diverse agricultural area, especially as you get out on the western side, and you'll see a mix of different types of agricultural uses and animal production. So this property is at 480 Almshouse Road, zoned AC, 2.3 acres with a single-family dwelling, and they have horses and chickens. Another property at 485 Almhouse Road, 5 acres, zoned AC, with a single-family dwelling. They have horses and chickens. 1185 Calmarsh Road, zoned AR, 2.1 acres, single-family dwelling, chickens and horses. 1954 Morgan's Choice Road, zoned AC, 4 acres, single-family dwelling, horses in the front yard. 3852 Pearson's Corner Road, zoned AR, 2.4 acres with a single-family dwelling, horses in the backyard. 2448 Pearson's Corner Road, zoned AR, 2.7 acres with a single-family dwelling, horses in the side yard. 1202 Jeb Road, zoned AR, 3.1 acres, single-family dwelling, horses in the side yard.
Mr. Pardee, just
Yes.
real quick, is there any distinction in your mind, or is it important for this board's consideration whether those horses are for sale versus poultry being for sale? Is that an issue in this case at all? Or
No,
is it just
I don't think it matters, honestly. I think
So if people have chickens in their yard, but they just like having chickens in their yard, they use them for their own personal use, does that enter into the equation at all?
I don't think it's relevant for tonight's purposes. It's a very good question, though. I think the only significance of if you're offering the animals or their whatever they produce, like eggs, for sale, you have to register with the Department of Agriculture. But if you just want to have chickens or horses in your yard, you do not, to my understanding, have to register with the Department of Agriculture. So I think the only significance of any sort of business activity is you have to register with the Department of Agriculture. But in terms of the Kent County zoning ordinance, it makes no difference. 1150 Jeb Road, zoned AR, 1 acre, single-family dwelling. They have horses. This is 285 Pearson's Corner Road, zoned AR, 6.6 acres, single-family dwelling with horses in the side yard. 579 Foxhole Road, zoned AR, 2.5 acres, single-family dwelling, horses in the front yard. 695 Tobacco Road, zoned AR, 2.8 acres. It says mobile home, but it's, as you can see, a log cabin. They have horses. 4293 Mud Mill Road, zoned AR, 0.65 acres, single-family dwelling. They actually have 2 little ponies in this, pretty cute little horses. 5142 Mud Mill Road, zoned AR, 12.8 acres, single-family, horses in the front yard. 6551 Mud Mill Road, zoned AR, half an acre, single-family dwelling, 2 horses in the backyard. You heard me say earlier, there's kind of a mix of different animals out there, and so I threw in some photos of those. But I will tell you that, and you'll see here in a little bit an exhibit that shows where all of these properties are relative to my client's property. And all of these are within very close proximity. I'll show you that in just a minute. But what's interesting is there's a mix. So here at 2140 Jeb Road, same road as my client's property, right down the street, they've got goats and sheep. That's Zoned AC, 4.34 acres with a single-family dwelling. 929 Alms House Road, zoned AC, 9.6 acres with a single-family dwelling, sheep in the front yard. 857 Alms House Road, zoned AC, 9.6 acres, single-family dwelling, sheep and cattle in the front yard. Now, this is a Google map showing the addresses of all of the properties I've just reviewed. And this is a zoom in of the immediate neighborhood. So you see Jeb Road, Alms House, Westville, and you even see a little bit of Willow Grove down there. As you zoom out, you see more. These are all pin drops for all of the pictures that you just saw, okay? Zoom out a little further, you see more. And this is a snapshot that captures all of the ones that I showed in the photographs. I'll tell you, having driven around, even today, driving around, I saw many others that, that aren't in this graphic. But what is in the graphic, there are 14 of the residences that you saw are within 1.5 miles, 1.5 miles of my client's property. 30, in other words, all of them are within 2 to 4 miles of my client's property. So our legal argument is that Kent County has no legal authority to restrict agricultural uses on AC zone properties. And that might come as a shock to you to hear me say that. But if you think about the history of Delaware, agriculture is the single most important, has always been the single most important industry in Delaware. In fact, it's the only industry that is protected from regulation by local government in the Delaware Constitution. Article 2, Section 25 of the Delaware Constitution provides that the General Assembly may enact laws under which the County of Kent may adopt zoning ordinances, laws, or rules limiting or restricting to specified districts and regulating therein buildings and structures according to their construction and the nature and extent of their use, as well as the use to be made of land in such districts, other than for agricultural purposes. Now, that provision of the Delaware Constitution was interpreted in a case decided in 1994 by Judge Henley Graves in Sussex County called State versus Clark. And in that case, Judge Henley Graves said Article 2, Section 25 of the Delaware Constitution, quote, clearly prohibits the counties and municipalities from telling anyone to what agricultural uses they may put their agriculturally zoned property. So the county can regulate buildings. They can tell you how far off the side yard and rear yard and front yard they have to be. They can tell you what types of materials they have to be constructed from. They can make sure that they comply with building codes. Even on AC properties, you can do that. And you do that. You issue building permits for pole barns all the time. What you can't do is you can't tell someone who owns agriculturally zoned property what they can or can't do as long as it is for an agricultural purpose. So as long as they're engaging in what your code calls crop production or animal production, you can't tell them they can't do that on their property. You can tell them how big their building has to be, how far off the lot line it has to be, what kind of materials it has to be constructed from, but you can't say to an owner of an AC zone property, you can't raise chickens on your property. You just can't.
Party,
yes.
To what extent is this case about the use versus the structure?
It's all about the use, 100% about the use. No one has said that the coops or structures on my client's property violate any building code. All that they've been told is that they can't have those chicken coops on their property.
Do you have an opinion as to whether or not the existing, I mean, is it true that the chicken coop you're referring to was constructed without a permit?
I don't think one is required. I don't know, but my understanding is there's no violation or citation regarding the structures. That the structures, as far as I understand it, are in compliance with whatever requirements there are. So there's no violation for constructing without a permit. So it's about the use and not the structure.
Okay.
So this constitutional protection, the General Assembly made sure that it was incorporated into Chapter 49 of the Delaware Code, which applies to Kent County. And what that delegation of authority says is that no zoning regulations shall apply to any land, building, greenhouse, or other structure proposed to be devoted to any agricultural use. That's in the Delaware Code, Chapter 49, that governs Kent County. Now, in your code, and I'll flip back real quick here. In your code, there is a reference to the definition of a farm. So in the definition of agriculture, it says, see also description of farm. And there's a definition of farm in your code. Oops, sorry. But what I'm going to submit to you is that because the code says that crop production and animal production are first permitted uses, as is any other agricultural use recognized by Delaware law, the definition of farm in section 205-54 of your code is irrelevant, completely legally irrelevant to this case. So that section of the code defines farm as a parcel of land to be, quote, primarily used for agricultural purposes, end quote. What I'm contending to you tonight is that a property does not need to qualify as a farm under the county code in order for the property to be used for agricultural purposes. If it did, all of those backyard flocks, all of those horses and chickens and goats and sheep would all be illegal, because those are not farms. Those are properties that are single-family residence properties that have animals on them. So you don't have to be a farm in order to engage in agricultural uses in Kent County. To the contrary, because the subject property is zoned AC, and because section 205-53B of the county code provides that AC zone properties may be used for any agricultural use, which includes animal production and any other agricultural use recognized by Delaware law, the Brennan's property does not need to qualify as a farm in order for the Brennans to engage in animal production. Remember, this is section 205-53B, permitted use table, agriculture. These uses include crop production and animal production. These uses also include any other agricultural use recognized by Delaware law. Now, it does refer to farm, but it doesn't say you have to be a farm in order to engage in agricultural uses. So we contend that that definition is irrelevant. I alluded to this earlier. If the Brennan property cannot be utilized for animal production on the theory that it doesn't qualify as a farm because it is not utilized, quote, primarily for agricultural purposes, end quote, that would mean that no owner of any AC zone property in Kent County could make any agricultural use of their property whenever someone in the planning department subjectively concludes that the agricultural use is secondary to the residential use of the property. There's a couple problems with that. How are you going to decide what is the primary use, whether the agricultural use is primary or the residential use is primary? How many acres does it take before you become a farm? Is a property that has chickens in the backyard that is only 1 acre, is that a farm? No. Is a property that is 10 acres that has chickens in the backyard a farm? You see, the problem is that if you're trying to define the property as to whether or not it fits the definition of a farm in your code, it's a completely subjective exercise. And if you conclude that what the Brennans are doing doesn't fit under your code, then that means you would have to shut down all 555 of those backyard flocks and every other backyard agricultural use, goats, sheep, horses, cows, pigs, whatever, that are operating on an AC zone property that also has as its primary use a residence. So that's a huge problem. I would imagine the county building would be stormed by people living on the west side. The other problem is that owners of AC zone properties would then be required to demonstrate that any agricultural use of their homestead was the primary use of their property in order to continue. In other words, it would encourage someone like my client to completely populate their entire backyard with so many chickens and turkeys that it became obvious to someone in the planning department that now that's the primary use of the property. And that's just a perversion of the code. It would be crazy to incentivize that. So that's the problem with the county's position here. For all of these reasons, we contend that the planning department's interpretation and application of the code under these facts violates the Delaware Constitution. We contend that it's discriminatory and unlawful. Even if the county does have the legal authority to regulate in this area, the point is, owners of AC zone properties can lawfully make agricultural uses of their property without being a farm. And requiring the Brennan property to qualify as a farm in order for the Brennan boys to conduct what is otherwise a lawful agricultural use of their property, when so many others are doing the exact same thing without having to qualify as a farm, would subject the Brennans to a different standard and disparate treatment relative to all others who are similarly situated. That is not only arbitrary and capricious, it's a violation of the Delaware Constitution, and it would be a violation of the Brennans' right to equal protection under the law. In conclusion, backyard flocks are very common. They're lawful on AC zone properties throughout Kent County. What the Brennan boys are doing is no different than what many others are lawfully doing throughout Kent County. Kent County has no legal authority to restrict agricultural uses on AC zone properties. That was the State versus Clark case that Judge Graves decided. And here, based on the facts that you've seen, the planning department's determination is not only wrong, it's discriminatory. So that is the extent of my PowerPoint. I'm happy to answer questions, but before I do, I just want to let you know kind of where I'm headed. I'm going to ask Donna Brennan to come up here in a minute. I have one other exhibit that I wanted to turn in, and it's a document printed by the Department of Agriculture that shows that the Brennan property is actually registered with the Department of Agriculture, and so I'll present that. So if you have any questions of me at this time, it might be a good opportunity to take a break, but I'm going to ask Donna to come up next, and I have a couple questions for her, and then she's going to make some comments. If you want to wait and save your questions until she's done, whatever your preference, Mr. Chair.
Yeah, I think we'll wait until after Ms. Brennan's done.
So Donna, would you please come forward? You're going to have to give your name and address and be sworn.
Hello, my name is Donna Brennan and I live at 2442 Jeb Road.
Brennan, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
So, Donna, I'm going to ask you just a few questions. You've been sworn. You helped me put together all the photographs that were shown in the PowerPoint, is that right?
Yes.
And are all the facts that were set forth in my PowerPoint presentation true and correct to the best of your knowledge?
Yes, sir.
So let me ask you, why did you submit paperwork to the county asking to be recognized as a farm?
Because when I received my violation, I made multiple phone calls to figure out how I can make this right. And I was advised by the Department of Planning that I had to register my flock as a farm by submitting proof that I could potentially make $1,000 or more a year, which was done and submitted.
Okay, you mentioned a notice of a violation. What was that violation for?
Because I had more than 5 chickens and a rooster.
Okay, it wasn't because of any structure on your property?
No, sir.
Okay. You never wanted to be classified as a farm, did you?
No, sir.
And you don't consider yourself a farm even now, is that right?
Nope.
Farm is a label or definition that the county planning office told you that you had to meet, is that right?
Correct.
Okay. I think you have a statement. I'll let you do that, and then the members of the board may have some questions.
Absolutely. All right, I'm going to hold it together. So as a dedicated parent, I've made significant sacrifices to empower my children, and my husband's children, obviously, to thrive to the path of success. My sons are not just dreaming. They're passionately pursuing their future roles in leadership. In agriculture sector, my oldest, who you heard from, Jeffrey, he's becoming a teacher in agriculture, eager to inspire and educate others, while my youngest aspires to manage a thriving poultry operation. To support their ambitions, we actually relocated to Kent County for this specific purpose. When we bought our house, it was zoned agriculture conservation. We were informed by the lawyer and other people that we would be able to do what we're doing because we're not in an HOA and we're not in a development. To support their ambitions, because we truly believe in their future. They're not on the streets, this is their life, this is what they do. Our land has potential to serve as a foundation for their dreams, enabling them not only to cultivate poultry, but also to actively participate in programs that elevate their status as future farmers of America. They're driven to gain higher degrees, engage in breeding, selling eggs, and exploring trading, all rooted for their love of agriculture. Over the past year, they've poured their heart into achieving both American and state degrees related to poultry farming. It would be utterly devastating to strip this opportunity away from them. Their passion and dedication deserve the chance to flourish. As a mother, it breaks my heart to think that this setback might face if they lose the opportunity. I implore you to support us in ensuring that my boys can follow their passion and contribute meaningfully to the agriculture community. We not only protect their dreams, but also invest in their future as agriculture itself.
Thank you, Donna. If you have members of the board that have questions at this time, we'd be happy to answer them.
I have one question. For the Brennan's deed, do you have a copy of the Brennan's deed of the property?
I don't have a copy of it.
Okay. Some time ago, I believe it was back in the 90s or the early 2000s, specifically in Kent County, the attorneys in that settlement began putting a paragraph in the deeds when it was being transferred that there could be agricultural smells, could be agricultural uses, and things of that nature. And Mr. Townsend, are you aware of that clause? Can you help me out on that?
I know what you're speaking of. It's that if you buy property in the vicinity of agricultural uses, that your deed might contain a clause, and there's some basis for it in the state code, I believe. I don't know under what circumstances it's required, but it says that farming activities, including noxious odors, there's a list, sounds and whatnot may occur in the vicinity. And there's some, also there might have been a requirement that for development in an agricultural area that there be a sign posted for, I guess, prospective purchasers to see that there's a farm in the vicinity of this new major subdivision and that you may be buying in an area that is in proximity to noxious odors, sounds, and again, I forget the list of concerns.
Okay, thank you.
So if I may, I think Mr. Townsend's right. I think there's a requirement in the Delaware Code that actually requires contracts for the purchase of property that's adjacent to a farm to have a disclosure. And I think it may require that there be some sort of deed restriction recorded to acknowledge that there are agricultural uses in the area. And the point really is that that's for the protection of the agricultural use, to show that anyone who buys a property and builds a home in that area is on notice that there are agricultural uses nearby, and those may entail noise, dust, odor, and so forth. So I haven't seen the Brennan's deed, but even if that language is not in their deed, I think it would still be language that would apply by virtue of the code.
Thank you.
If you don't have any other questions, that concludes our presentation at the moment. I will point out, since the word subdivision was mentioned, this area is not a residential subdivision. There is no subdivision plan. There was no zoning approval. These are all a bunch of homes constructed on county roads. There's no HOA and no subdivision. They're all AC zone properties.
May I? Just real quick, with regard to State versus Clark, our Henley Graves included some language, or continued to the effect that while the constitutional provision clearly prohibits counties and municipalities from telling anyone to what agricultural uses they might put their agriculturally zoned property, that provision clearly allows the counties and municipalities to regulate all other zoning matters. These other zoning matters encompass the requirements of building permits for all buildings, including those put to an agricultural use. And in that case, I think the defendant, who kind of stands in the shoes of the Brennans, was denied its motion, if you recall, right?
Yeah, so what Judge Graves, and that's a different set of facts than what we have here, but in that case, the property owner had some buildings, some structures that were violating the county code. And so Judge Graves said, you can't...
Coops. They were chicken coops, weren't they?
Right. So what he said in that case is the county could regulate the structures, but they can't tell the property owner you can't make that use. So you can, as I was trying to say earlier, you can say the building has to be at least so many square feet. It has to be set back so far. It has to be constructed of materials consistent with our building code. It has to meet all of our other zoning requirements, but you can't tell the property owner they can't make that use of the property. So you could say to the Brennans, your coops have to be 25 feet off the rear yard. They have to be constructed according to some building code standard. They can't be any larger than so big or what have you, but you can't tell them that they can't have chickens. That's kind of the point. So it's, Mr. Townsend's early question was spot on. What we're talking about tonight is the use, not the structure. And so the county can regulate the structure. It can't regulate the use in terms of prohibiting it.
Can you just recap the farm label that county established? Was it the 5 types? Was it 5 types of chicken? The amount of chickens?
Yeah, my understanding is you can have no more than 5 chickens. You can't have any roosters. That's what the county requirement is. And it actually, I think, comes up in the county's presentation. They make reference to section 205-34 of the code, which says, and it's entitled Keeping of Poultry, Pigeons, Ducks, and Similar Animals. And I'm sure you'll hear my colleagues talk about that section. It's in their presentation. That code section says a couple of things. It says, keeping of such animals shall not be permitted on lots smaller than 15,000 square feet in lot area. So that's 1/3 of an acre, roughly, right? You can't have poultry, pigeons, ducks, or similar animals on less than 1/3 of an acre. The second provision in that section says no more than 5 such animals shall be permitted on a residential lot. I suspect you'll hear my colleagues say, well, this is a residential lot. That's true in the sense that it has a house on it, what is a AC zoned property? It's not a residentially zoned property, it's an agriculturally zoned property. And so this provision, we would contend, has no application to the Brennan property. But to answer, sorry, that's a long way of answering your
No, that's
question.
fine. So it's the number, it's just 5, not 5 different types or breeds, it's just
Yeah,
5
if the Brennans
animals
only,
in general.
I'm sorry, yeah, I didn't mean to interrupt, but if the Brennans only had 5 chickens and no roosters, we wouldn't be here.
Is there a reason why they can't just have 5? I don't mean to sound ignorant to the subject. Is there like at 6 you get more credits, or?
Good question. I don't know the answer to that, but there may be, and I'll let them answer it. My reaction would be that they're not required. This provision doesn't apply to their property, so they're not limited to 5. But they may be able to tell you why they need more than 5. I mean, I think the point is the boys are trying to get an education and get a degree. And Jeffrey may be able to talk a little bit about some of the degree requirements in terms of what they have to do and what they have to learn. I suspect he'll probably tell you that it's kind of hard to qualify for all of those programs and get that degree if you only have 5 chickens.
Hello. So on the topic of the fact that we have more than 5 birds, it's hard to do the business that we're trying to implement with just 5 birds. Normally speaking, if you do get the best layers, which would be any kind, you would get 5 eggs a day from those birds, and that's not even half of a carton of eggs. Not only talking about that, when you're looking at the educational side of it, which is the point I'm coming from, having one kind of bird, yes, that would help with the anatomy, but that wouldn't help with like species and stuff. There are thousands of ways you can use birds. You have egg layers, you have meat birds, you have ornamental birds. We also have turkeys, we also have ducks, and that all stuff is stuff that would help influence the future of teaching with at least my perspective on it. It's
Why do you need that many birds to be able to complete your American degree?
So for my American degree, which is the degree I'm going for in FFA right now, I need over $10,000 invested, along with more than 300 total hours invested into it. And 5 birds not only is just not going to get me that much time into it, I'm also not just going to invest that much money into 5 birds alone. It's not going to get to the feed quantity, it's not going to get to the housing quantity, it's not going to get to the water quantity.
Ms. Hudson, does that answer your question?
Yeah, with the $10,000 that you have to have towards your scholarship, is that merely just in chickens sold and eggs sold, or?
It's in both money invested into, well, it's specifically just money invested into the SAE. The money that I receive out of it doesn't go towards it at all.
Thank you.
Thank you.
So Jeffrey, am I correct? It would include the cost of the coops and the feed and everything you need to raise the birds?
So it would include the feed, it would include any environmental stuff that we have, it would include the runs, it would include the cost of buying the birds, it would include the coop, and everything that goes into the birds.
Thank you. Anything else?
I think that's it.
Thank you very much. I believe you'll hear from my colleagues, and then I'll be back.
Very good. I think we need a quick break, 5-minute break.
Oh, thank you.
It's done through, it's called the Andy program if you Google it.
Let me make sure I don't have an objection. I can't imagine I do, but let me look.
I don't know
You,
who-
you better check with him as well, make sure he has no objection. Better check, yeah, Mr. Party, thank you.
Then you can fry it up.
I was gonna tell them. Yeah, I didn't, just, Delaware code requires them to have a nutrient management plan. Do they have that?
I don't know. I don't think we do.
Okay, so if you go and get like a nutrient management plan, they'll go through like all the requirements. But if you have more than 8 chickens, you have to get a nutrient management.
I don't have any objection.
And we have one, but, well, I don't know if you do, because you have to be 100 feet from any ditch, and then you have to be 200 feet from a neighbor. Okay?
Yes, I think there's different provisions.
If you have more than 8 chickens, they consider it like a lot of chickens, and you have to have a Delaware nutrient management plan. And they'll go through all that at the Annie program. Okay. Yeah, good luck, guys. You can come up any, we always need hands. You can come help anytime. We got work.
And so he just notifies you on the card and
We-
for him?
Yeah, you
For
can call
work?
me, yep, and then,
Okay.
yeah, I mean, good luck.
Thank you.
Mm. Yeah.
I'll be right back.
So you clean out one, move one over, and
Yeah, ideally the layouts are short. But I think the watershed is gonna be the biggest issue. They like determine where the water goes to. So I do think that like we might have. I built our farm, so I had to go through like Denrick and go through like the HUAP. They call it HUAP.
Denrick has been to our house. They call them,
Yeah.
Department of Agriculture has been to our house, they call them itches.
Okay.
So they've called everybody.
Yeah. Well, yeah, I'm just here being.
No, I get it, yeah.
For us, like avian influenza, the reason it's like kicking up so much is because of all the backyard chickens.
Yeah.
And I think every backyard chicken is great.
Yeah.
Yeah, no, you're fine.
fine, thank you. Not that thin anymore. You guys can go first. Yes. Me, then public comment, then okay.
Yeah. Are you working on it? No. Yes. Yeah. No, you're good, baby. Thank you for the compliment. I'll have to keep it. You know,
Turn it on.
Okay.
Jamie, can you please call roll?
Yes, sir. Mr. Gallo?
Here.
Mr. Carter?
Here.
Mr. Jones?
Here.
Ms. Hudson?
Here.
Ms. Denny?
Here.
Mr. Cusick?
Here.
Thank you. That's 6 still present.
Thank you. And you can begin.
Good evening, Commissioners. My name is Lisa Hatfield, and I am from the firm of Conley Gallagher, representing the Planning Department today. With me, I'd like to introduce my colleague, Grace Best, who I think is attending her first meeting, possibly, right? So welcome to Grace. I note that this presentation essentially ended with a comment that the farm designation was irrelevant, completely irrelevant. And I would ask you why we're here today if that's the case. This appeal is about the planning services decision that this was not a farm, that this didn't qualify as a farm. The appeal filed itself states the Kent County Planning Department has denied our submission to have a parcel of land labeled a farm. That's what we're here for tonight. Appellant has conflated those issues with the chickens because, quite frankly, if it's not found to be a farm, it limits how many chickens they can have. That's not what is before this board this evening. There was indeed a violation issued, which appellant seemingly hasn't reread, as it did indeed address a setback. So the complaint that was filed and responded to by the Division of Planning Services indicated that there were roosters, more than 5 chickens, and that the coops on the property did not meet the setback requirements. We learned tonight that, quite frankly, they probably did not have permits to build those coops either. When the violation was issued, there was no response to that violation other than what can we do? And they were told that if it was designated a farm, they could have more birds. And so they filed that application, which was denied. Again, that is the only issue that is on appeal before this board tonight. So I ask you, is this a farm? This particular area of property is developed with approximately 25 single-family homes, each one on approximately a 1-acre lot. They're next to one another. The Jeb property, the 2442 Jeb property, is surrounded by, as you can see, 3 houses, 4 houses to the right, 6 houses to the left, 3 houses behind. These are the people that are listening to those birds day after day. These are the people that are smelling those birds day after day. If this is a farm, then it would qualify for more birds. But there's a reason that there's a designation limiting the number of birds in a residential area. And that is that noise and that is that smell. Whoops, wrong way. So what does your code define as a farm? A farm is a parcel of land that is primarily used for agricultural purposes. The key word here is primarily. Appellant also indicated that this could be a subjective term. I submit that it's not subjective. Primarily is a common word in our language. And under the dictionary definition, and I need my glasses, it says for the most part, for the most part. If you're using your land, for the most part, for an agricultural use, certainly raising of poultry and poultry products qualifies as part of that use. But again, this has to be your primary purpose. And you don't make it your primary purpose by simply adding more and more birds. It's the primary purpose of the land. What is the primary purpose of the land? I think probably everybody in this room is sympathetic to some young men wanting to further a career and be able to pursue their dream. I don't think there's anybody in this room that's probably not sympathetic to that. But was that the primary purpose of this property? Is this a place where this family lives, or is this a place where they're farming and sustaining their livelihood on this piece of property? It is important that this is zoned residential. It does make a difference that it's zoned residential. And the planning staff doesn't disagree that this is an agricultural use, but it is not the primary use. And if it's not the primary use, it doesn't fit the definition of the farm under the Kent County Code. I remind you again where this is located. This is a picture of the property that is across the street. One house, lots of acres, lots of crop. Probably a farm. This is a picture of the property just below, and I'm going to call it a neighborhood. It might not have gone through a formal subdivision process, but 25 houses in a cluster is a neighborhood. Just below that is, so this is the property the other side. Again, lots of crop, very few homes, probably a farm. Remind you again that we're looking at what is the primary purpose. This is the picture of 244 Jeb Road off of Zillow at the time it went for sale last year in 2024. This is how the property, I assume, looked when it was purchased, as this is how it was advertised on Zillow. You can see there's a back porch, a fire pit, regular grass to be cut, everything that a residential property would have. This is the property from Google Earth just a few days ago. Well, actually, it probably wasn't a few days ago because the planning services pictures have another coop on there now. But clearly after it was purchased in 2024, because they've added the coop in the back left corner. Again, nice back porch, place to sit and have fire, you know, marshmallows by the fire, cut your grass. This is a residential property. I think this map is pretty telling because it really shows the plot division and how clustered these homes are. Again, greater than 25 homes on the left upper portion. I didn't count the right lower portion, but clearly another neighborhood right nearby. So it is zoned in the AC district. There's no doubt that it's agricultural conservation district, but it is coded as a residential property because that's what it is used for. The agricultural conservation district is by code a district that is reserved for agricultural uses, but also low-density residential. That's what this is, low-density residential. And your comprehensive plan confirms that this was the purpose that the county listed this property or wanted in the agricultural district. Your most recent comprehensive plan states that areas of large-scale residential development are not encouraged, but if they happen in the agricultural areas, they are to be low density. Hence your 1 acre lots, 25 in an area. It's interesting to note that on average in Kent County, a farm is 200 acres, and the median size is 40 acres. That's your average size farm and median size farm here in Kent County. This is 1 acre. Again, planning services does not deny that this is a permitted use. They have a right to have an agricultural use. It's not an unfettered use, though. I think at one point appellant stated that they were prohibited from this use. They're not prohibited from this use. They can have chickens, they can have their coop, they can have 5 birds. That's what a residential district allows. So 955 Jeb Road, and I don't have as many as appellant had, but I wanted to see the aerial view of some of these properties. So 955 Jeb Road, that particular property, when shown to you on the appellant slide, I could literally count 5 chickens. There were 5 chickens in that photograph. I don't know if they have more or not, but I imagine appellant doesn't either. That's the information we're missing through this whole presentation. 1202 Jeb Road, lot more space. They have chickens. I don't know if they have 5 chickens or not, but they certainly do have a lot more space. Why is this important? Because violations are driven by complaints, and complaints are driven by neighbors. So the fact that all these other homes that appellant have brought up may have more chickens, please don't be fooled in thinking that the county's allowing this. The county doesn't drive around and look for violations. The county's system is complaint driven. So it is important, and what this board doesn't have before you today, do they have 5 chickens or do they have 25? We don't know. We have no idea. And that argument, the age-old argument of everybody else is doing it so I can too, it just doesn't fly. There's a code that you have to comply with whether or not everybody else is doing it. So what we need to know, and we don't know, is what do all these properties have? Have they applied to be a farm? Have they gotten a violation? Do they have 5 chickens or do they have 25? It's irrelevant. What matters is this property. And again, although we are here to decide whether it's a farm or not, appellant has brought up these issues and we must address them. 1150 Jeb Road, same thing. A lot more land, might qualify for a farm. It might. It's listed as residential, I don't know. Might only have 5 chickens, so they never applied to be a farm. I don't know. Same with the Alms House properties. And then these last 2 Alms House properties I included to show you it's a little more dense there. I want to be fair. There's a little more density there. There's a little more houses there. They have chickens. They might have 5. We don't know, but they don't have a violation that we know of, and they're not before this board today. Westville Road, this one is classified as a farm. So of the ones that I pooled, and the only reason I limited what I pooled is this was from the initial presentation and not the revised presentation, so this is all I had. Of all those properties, two are farms. Everything else is residential, and everything except for 2 are over an acre. And again, it's important that we have no idea what numbers they're using on their property. So again, why is this important? Well, we talked about 20534 in your code and how having it be a residential property limits them. That's the reason that they want a farm designation. Although, again, today they've said it doesn't matter if it's a farm or not. So we'll discuss that shortly. A residential property can have just no more than 5 birds. They have to be registered, which they are. Coop has to have at least 4 feet for every animal. They have to be set back, which we know the setback is inappropriate right now. And the odor can't be discernible from across property lines. Roosters are not permitted, and again, this is a noise and smell issue in residential properties. So what are the permitted uses? When you are making a decision as to whether a property is residential or farm, the bottom line is it can't be both. You can have one primary use per lot unless you are segregated. So it's important that it be designated one or the other, which will then determine the number of birds that can be on the lot. Oh, sorry, I keep hitting this wrong button. So this is a view of an aerial view of the property with the direct neighbors. I really wanted to see how close these are. This is not a situation where we're seeing those fields that I showed you earlier in between the residences. These residences, an acre's not much. It's not much. And as the appellant stated, the properties that are surrounding this that you were shown pictures of, they're about 1.5 miles. He said, I think 1.5 miles to maybe even 4 miles away. I don't know if any of you ever run a mile, but I used to run a lot, and 1 mile is pretty far. It would be hard pressed for the odor and the sounds to travel over 1 mile back to a residence. That's not the situation here. These houses are not 1 mile apart. In fact, they're quite on top of each other. I'd like to address what is basically the main part of the argument. There's 2 arguments here. One is everybody else is doing it, so we can too. And the second is you can't regulate us. That's absurd. There are definitely some provisions in the case law and the code that say you can't regulate some items. No, you can't regulate uses. That's correct. You're not. They're allowed to have chickens. You're not prohibiting it. They're allowed to have chickens. It's a permitted use, and they can operate under that use. Appellant has indicated that the State v. Clark case then says that you can't regulate anything other than building permits. He concedes that you can do building permits. Also not true. The State v. Clark case was actually a criminal matter where the defendant was charged with violations of the code for building chicken coops without permits. When it went to court, the appellant, similar to here, argued that the Constitution prevents them from doing any of these uses. And as the appellant told you, or from preventing any of the uses. And as the appellant told you in their presentation, the judge held that they could not, that is true, they cannot tell anyone what agricultural uses they can do. But he continued, likewise, the provision clearly allows the counties and municipalities to regulate all other zoning matters. All other zoning matters, not just building permits. In this case, it was building permits, and he went on to say that includes building permits. But the decision said all other zoning matters. What other zoning matters do we have? We have setbacks, we have density, we have population. There's all kinds of zoning regulations. Only thing that is prohibited by the Constitution is uses. And that is not being denied. Appellant then goes on to say that 9 Del C 4901 allows, basically the legislature said that the county cannot regulate that either. That somehow the state code has decided that Kent County can't put any regulations, not just uses, but they can't regulate agricultural land, period. That is also not true. In the appellant's presentation, they stop. Let me just pull it up here. With this sentence. 9 Del C 49B provides that notwithstanding the broad delegation of zoning power allowed to Kent County in 9 Del C 4901, density, population, setbacks, buildings, no zoning regulation shall apply to any land, building, greenhouse, or other structure proposed to be devoted for any agricultural use. And there it ends. But the next sentence begins, for purposes of this subsection, any land, building, greenhouse, or structure shall be deemed to be devoted to agricultural use if. So it must be devoted to agricultural use to not be regulated under Section A, and it's devoted to agricultural use if, 1, the land, building, greenhouse, or structure is assessed pursuant to 8335 of this title. 8335 is rather long, and I'm not going to take up more of your time with that. But I would submit that they don't qualify under that because I looked at it, but also the burden of proof is not on planning services. The burden of proof is on the appellant, and they have made no indication that they fall under this section of the code. 2, the land, building, greenhouse, or structure is within an agricultural preservation district pursuant to Chapter 9 of Title III. Under Chapter 9 of Title III, a preservation, agricultural that falls under the preservation district requires 200 acres, or if less than 200 acres, a request for a waiver and to be allowed into the preservation district. We have no evidence that that occurred either. 3, the person who leases or otherwise controls the land is required to implement a nutrient plan or agricultural waste management plan. We have no evidence of either of those being submitted. 4, the building or greenhouse is devoted and meets the needs and qualifications for payments under compensation pursuant to a soil conservation program with an agreement with the federal government. We don't have any evidence of that. And last, that the land, building, or structure is a farm, market, or roadside stand, which may be true. Don't know. But the statute requires that all 5 be met. And while I can't get into the brains of the legislature, what I assume, what is likely to be true reading this, is that in this situation they are regulated by the state and by the federal government, and in that situation they say, Kent County, hands off. But if it is not devoted to agriculture and it does not meet these 5 requirements, then it falls under Section A, and Kent County can indeed regulate the agricultural conservation district. I couldn't resist using the old chicken or the egg. I just couldn't resist. So this is a question of which came first. It really is. I mean, you're looking at a primary purpose, right? So the question is, were there eggs that they needed a house to sustain, or was there a house that they needed to live in and wanted to then also have the hobby for their children? And that's what happened here. This is a primary residence. This is a family. Mom has a job outside of the home. Dad has a job outside of the home. The children have a hobby in the backyard. I'm not saying it's a small hobby. It's a wonderful hobby. We got kids on the streets. I do not disagree. But it is not a hobby that you can have in a residential district that is this dense. I'll give you one last look at the backyard. If you don't think that this primarily is used for agricultural purposes, you have to affirm the decision, the only decision that really is before you, that this is not a farm. If you choose to address whether or not they can have more chickens, if you choose to conflate these issues, which you can, I think there's more than enough here before you from the state code, from the case law, that you are permitted to regulate your code. You can't stop them from using it for chickens, but you can regulate how they use it for chickens. And that is what is being done here. This property can have 5 birds. This property can have their coop if they put it set back properly. But that's all they can do in a residential district. And we ask that you would affirm the decision of the planning services. Any questions?
Any questions from the board?
I just want to verify. So the question before us is whether or not the staff was correct in saying this is not a farm?
That is correct.
That is the only question.
That is the only thing listed on the notice of appeal, correct?
During your testimony, you referred to residential, which obviously that's the primary use of this property. But the zoning is AR, is that correct?
That is correct. AC.
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 Which permits a dwelling to be placed on it for residential use.
That is correct.
Correct. Where does the 5 chickens, does that fall under a residential zoned property? Does it also apply to the agricultural conservation?
It is a residential use property, and so therefore, yes, it applies to
Is that how it is described in the code? Is it described in the code that AC properties, if they are being used primarily for residential use, they cannot have more than 5 chickens?
So let me just pull up just back a couple slides. Your code does not differentiate the zones, it differentiates the purpose, residential versus farm, okay?
But this is not a farm, I'm not asking about a farm. I'm
I
asking
understand.
about the zoning as agricultural conservation permits a residential dwelling to be placed on that lot. Correct? Be it
Correct.
1 acre, 2 acres, 3 acres, whatever it may be.
Correct.
Not talking about whether or not it's classified as a farm.
Understood.
Under the AC zoning, they're permitted to build a residential dwelling as their primary residence, whatever the case might be.
Yes.
My question is where is that 5 birds? Does that 5 birds fall under that AC, or is it for residentially zoned property? Because this is not a residentially zoned property.
Understood. So under your code, 20534, no more than 5 such animals shall be permitted on a residential lot.
Is that referring to residential zoning is my question.
So the way you classify your properties is first the zoning, there's a zoning designation, and there's a classification as residential, farm, single family, duplex, different. That code says residential lot, which would indicate the use, not the zoning.
Thank you.
Any other questions?
Nope.
It's just a small one. We saw pictures of horses at one point. I mean, do you have any comment on like whether the number of horses or horses that would be used for recreational purposes? I mean, how does that factor into this equation?
It doesn't. It really doesn't. I'd be very honest, I did not research the regulation of horses because that's not before the board, and I didn't want to use the planning commission's time or the planning department's time researching something that really is not relevant. The other reason that I feel that it is not relevant is, again, because on all of those pictures, we have no idea what the numbers are, what they've applied for, what the use is. I think, Mr. Thompson, as you pointed out earlier, I believe it was you, we don't know if they're selling the horses, breeding the horses, just riding the horses. Do they have a nonprofit equest? I know nothing to be able to, even if I research the code on that issue, be able to really make any determination whether they were compliant or not, and I don't think that it is relevant to this proceeding.
And once again, the application that was filed is appealing a decision made by an administrative official that what?
I'll read you the application if I may. The Kent County Planning Department has denied our submission to have a parcel of land labeled as a farm. And then under state reasons supporting the appeal, it reads, the decision not to classify the parcel as a farm is currently under formal appeal. The designation is believed to be inconsistent with the Kent County zoning code and does not adequately consider the property's unique characteristics or the surrounding area. I have proper documentation demonstrating a projected income of over $1,000 per year, which supports our classification of the property as a farm in accordance with Kent County regulations. I respectfully request the opportunity to articulate the importance of maintaining our ability to raise poultry as it directly impacts my son's future pursuit of a Future Farmers America state degree and American degree. Thank you for your attention to this matter. That's exactly how it reads. If there's nothing further, I'll sit down.
Good, yep, thank you.
Huh?
Will we be doing opposition now? Or does Mr. Pardee have?
Because it's not a variance situation, I don't think we categorize people as whether they're in opposition or in favor of. We just ask the public if they have comment.
All right, we'll do public input at this time, and we're going to limit to 3 minutes. And just try not to repeat, just to respect everyone's time.
So whoever would like to go first, please come forward, state your name and address, and allow me to administer the oath.
Sherilyn Hummel, 2476 Jeb Road, Camden.
And for you and anyone else who approaches, please adjust the mic so we can make sure and hear you, number one, and also pick up your remarks on a recording that we're making at the present time. So I apologize. Your name again, ma'am?
Sherilyn Hummel.
Hummel?
2476 Jeb Road.
Okay, Ms. Hummel, do
Yes.
you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Please proceed.
I want to thank you for the opportunity to speak tonight to contribute to this important discussion. I want to begin by acknowledging that I believe the Brennan's intentions have been sincere. They moved from Newcastle under the impression that this was agricultural land. Unfortunately, they're misinformed, and the process they followed is flawed from the very beginning. You may not be aware, but the Brennans live in a 6-lot residential subdivision. I'm part of that subdivision. It's clearly defined in our deeds, and yet here we're forced to argue against them attempting to rezone it to become a farm. They initially contacted the agriculture department, which allowed them to register 60 birds. But how is it possible to approve 60 birds without confirming the property complies with the local zoning laws, especially when it's just a 1-acre lot in a residential area? Why isn't a zoning check required to approve this process before granting the permission for all these birds? And has there been any follow-up, any health inspections to ensure the birds are properly cared for? And more importantly, are they being checked for carrying diseases and that can affect the neighboring flocks? If the zoning laws had been checked, they would have been informed that the property is limited to 5 fowls and no roosters. The property is zoned AC, which is primary residential where we are located, and it does not allow farming and commercial operations on this kind of 1-acre lot. When the zoning office did get involved, they considered allowing this rezoning based on new interpretation of what is permitted to be a farm without holding a public hearing. They just were going to make the decision, and that's the way it was going to be. That was deeply concerning, and any change that could alter the character of our residential neighborhood should involve the community through open meetings and transparent discussion. While the Brennans did inform some of the neighbors about their plans, it was only after the process was already underway. That left many of us confused and concerned, and ultimately led to phone calls, emails, and letters to local officials and state representatives. Unfortunately, the situation escalated. After several rezoning requests, after the zoning request was denied, the Brennans continued to buy and sell birds and build additional pens and coops. This has caused ongoing disruptions, noise, odors, and general nuisance, threatening our peaceful residential nature of our neighborhood. And that brings me to the larger point. Zoning rules exist for a reason. When they're ignored or sidestepped, the consequences affect more than just one household. Let's be clear about these. They say 5 fowl, no roosters, and basically they're doing retail sales. So that's really not included. You're not even allowed to do that on residential. Home-based businesses such as small scale, low impact, and they're supposed to be small scaled, low impact, and non-disruptive to the neighbors.
Ma'am, I'm sorry, that's your 3 minutes.
Okay, I got a letter said it was 5.
3 minutes.
May I continue? I'm the only one that.
Yes, you could continue.
Thank you. So anyway, right now, there's coops on the property line. There's a structure over the septic drain system, and the operation continues even after it was denied. They're basically running a business on a residential lot, and they're not following the strict regulations. The business can't disrupt your neighbors, alter the residential character of property. You can't operate a retail business from your home. You can't create increased traffic, and you can't employ outside help. The bottom line is what's happening here is just a zoning violation. The bottom line is what's happening here isn't just a zoning violation. It doesn't even meet the standards of a home-based business. Now, I do want to acknowledge the Brennans have made improvements, like erecting a big, beautiful privacy fence. And while that's appreciated and has improved my view, let's be honest, a fence doesn't change the fact that these remain in violation of several codes. I understand that due to a number of complaints and rising interest in backyard chickens, updates to the zoning laws are underway. The proposed change will limit residential lots under 2 acres to no more than 5 fowl and still no roosters. This is a step in the right direction. I'll just finish by saying that I don't think an organization like the C's Rodney FFA would ever support violating zoning laws to advance agricultural education. They teach responsibility, structure, and proper animal care. That's why it's especially troubling to see the children and adults cleaning the bird pens without protective footwear or masks. This raises serious concerns about health, safety, and supervision, standards that the responsible programs of FFA would never condone. My husband's a retired contractor and actually contracted histoplasmosis several years ago, working in an attic contaminated with dried bird droppings. That disease is contracted by inhaling fungal spores from droppings. So for us, this isn't just a possibility, it's personal and it's real. Thank you for your time and for standing for the integrity and the well-being of our community. And this is the picture of what it looks like now, other than the fence, not like she showed. It has several more buildings.
We can't see that, or I couldn't see.
Yeah, can you pass that picture around, please?
Do you, Mr. Pardee needs.
That's not what it looks like today.
This picture's not what it looks like today?
Doesn't show the fence. I'll talk about that in rebuttal.
Would anyone else come up? Please try to stick within 3 minutes, please.
Jeff Iverson, 2504 Jeb Road, Wyoming, Delaware.
Sir, you're still under oath.
Okay. First of all, my property is 150 feet from the Brennan property. This area was subdivided into 1 acre residential lots with original intention being residential with no farm animals as per our original deed restrictions. Now, I brought my deed with me, and it is considered a subdivision. It's a Thomas H. Webb subdivision, as we were kind of put on spoken earlier that it was not a subdivision, but it is a subdivision. I'm opposed to changing the Brennan property designation to a farm. The property presently is housing at least 60 poultry. That's turkeys and chickens, 60. And that's according to Jeff Brennan. We had a conversation a couple weeks ago in the backyard, and he acknowledged 60. I think it's probably more, but that's what he acknowledged. This this is producing a major fly, rodent, and odor issue in the neighborhood. These houses are, most of the houses on that road are probably $500,000 or more. And this is creating a real problem. The Brennans have at least 60 poultry plus roosters, which there's not supposed to be any roosters on the property either, but they have them. Allowing a farm status on this residential property would have an adverse effect on neighboring property values and my property value. I've lived here for over 30 years and have abided by the county regulations. Please protect our residential properties by voting no to changing this status. And I brought my deed along. This is my original deed from 1989, okay? Now, the restrictions in my deed say the entire area is restricted to residences and buildings to be used in connection with the same. And it also says the keeping of livestock or farm animals on said premises is forbidden with the exception of pets. Now, this was the Thomas Webb subdivision, my original deed. Now, some of these things are probably sunsetted, but I'm just telling you the intent of that area is residential. And I want to keep it that way. So, anyway, thank you for your time.
Thank you.
Any questions? Okay, thank you.
Thank you. Anyone else want to give public testimony?
Good evening. My name is Wilbur Myers. I live at 21 Milbourne Manor Drive. And
That's in Kent County, right?
Yes, Camden.
So, Mr. Myers, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, sir. I also own the lot directly west of Mr. Brennan's property. I have to agree with Jeff. All those properties were restricted. They were a subdivision. The definition of the Kent County subdivision is under Title IX, Chapter 48, Article 11, Section A. I helped develop these properties through the years. We've invested a lot. We're all neighbors. We've been there more than 20 years, most of us. We need some protection from something like this happening. Mr. Pardee kept bringing up backyard flocks. We have no problem with that. 5 birds, 6 birds, whatever it is, no roosters. We don't have a problem with that. If somebody wants a couple chickens, that's fine. But when you have that many, and I live probably 4 properties down to the west, south and west of his, and I can hear his birds. So, I mean, the roosters, the turkeys, you can hear all that. There's also a problem I have with all those birds there of polluting our water system. We all have shallow wells. The Alabama's Mill Stream runs 290 feet directly west of his property, parallel with his property. All of that water goes into Isaac's Branch, Wyoming Mill Pond, and on out to Delaware Bay. We don't need any problems with that. Other than that, I think it's been covered, most of us. But like I said, most of us have been there 20 years plus. We've raised our kids there. We've raised our grandchildren there. It's been quiet. Everyone gets along. And then this gets dropped in our lap. And I believe as Miss Denny said, she likes to follow the code. The code says you have a certain amount of birds in a backyard flock. And that hasn't been taken care of. Thank you. Any question?
Nope. Thank you.
Is there anyone else that would like to speak?
Good evening, everyone. Good to see you. My name is David Lawson. I'm a state senator of the 15th Senatorial District. I live at, where do I live? 2557 Westville Road, Maryville, Delaware.
Sir, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. Far be it for me to stand in the way of anyone's future, and I certainly don't want to impinge them or slow them up in any way, shape, or form. But there's a neighborhood to be considered, and that neighborhood is here. I was raised on a farm. I know how far the smell goes. You know when the chicken manure is spread for miles around. You know the contamination. In fact, I believe there's a rule by ag that once you spread the chicken manure, it must be disked in within 72 hours. I looked at the pictures, and the code says for 4 square feet per bird. I didn't see that with those turkeys or any of the other birds in those pens. Look pretty tight. I think that we have a problem here of someone coming into a neighborhood from a county which was highly populated and thinking they were moving into an ag center, and they didn't. They moved into a residential area. And it is residential, there's no doubt about it. That's been proven time and time again. I would ask that you deny the request for the Brennans and their farm. They're being classified as a farm. I'm more than happy to answer any questions if you have any.
Any questions? Nope.
Seeing none, I'll go sit down.
Appreciate it. Thank you.
Is there anyone else that would like to speak on this application?
Debbie Beatty, 4 Millbar Manor Drive, Camden, Wyoming, Delaware.
Ma'am, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. Okay, so we moved to Camden, Wyoming in 2019 due to the nice, quiet neighborhood with great, quiet neighbors where everyone keeps their property neat and tidy, and they're very respectful to one another. Basically, if we wanted to live next to a poultry farm, regardless of the size, we would have moved next to one. So what's the magic number of livestock, whether it be chickens, turkeys, or anything else, that would be permitted on the property at 2442 Jeb Road? Like worst case scenario, 60, 100, 1,000? Will their front yard be loaded with livestock as well? I mean, this is a major concern. It's like, you know, where does it stop on that? So the 60 chickens and turkeys they have now that we know of, not including the baby chicks in their garage and the 5 dogs and indoor birds that they also have, it can be loud at times. The roosters are loud, and they have no idea what time it is. So if it's 3:40 in the morning while we're sleeping, it's a little disrespectful to every one of us in hearing distance. Okay, so people within a 0.7 mile radius of, say, a 60 count backyard poultry farm or flock, they could face the health concerns primarily related to pathogens, respiratory issues from airborne dust and bioaerosols. And I'll skip over that because I know I'm limited on time. Even small chicken farms must practice meticulous cleaning to protect their flocks from disease, including protecting the health and well-being of their community. Many of us have witnessed the clutter at 2442 Jeb Road. They have recently installed a fencing compound around their livestock, which makes it harder to see the actual upkeep. If it was cluttered prior to the privacy fence, I'm not sure if the word meticulous, as Kent County actually has, I got that word from Kent County, if the word meticulous would ever apply now. The large number of birds in a residential yard increases the potential for health risk in the community compared to a small flock of a few chickens as the law currently allows. To sum it up, we want our nice neighborhood, we want a quiet neighborhood to stay as a nice, quiet neighborhood. The excessive noise, odor, predators, rodents, airborne illnesses, and the potential to decrease our property values are why we are opposing to have 2442 Jeb Road be a farm, having more than 5 chickens or livestock in general. If by chance the court is in favor of this potential farm, this will probably open up a major can of worms. I'm sure the Brennans are very nice people, but the bottom line is, if they wanted a farm, they should have bought a farm, not buy a house in a residential area and flip the entire neighborhood upside down. Thank you for your time.
Thank you. Any questions? Seeing none.
Thank you.
Is there anyone else that would like to speak? There's no one online either.
Before we continue, just a quick remark. Some of the testimony we heard from the public related to the presence of restrictions that forbid certain activities on property, and it may come as a surprise to you. I know the board's heard this before, but those restrictions are considered private contractual restrictions that the county does not enforce. So I'm not saying they're not enforceable, but they're not enforceable by the county. So that this subject comes up very often, and it can be very disappointing to people who would like for someone else to enforce their restrictions for them. I'm sure Mr. Pardee would spend more time on this if I don't make these remarks, but the goal is to keep things moving here, and that's just a kind of a harsh reality that I would like to remind the board members of as well. Thank you.
Mr. Chair, I believe that we agreed I would have some time for rebuttal after public comment.
Absolutely.
So I'll try to be brief. Respectfully, the county's presentation is simply off point. The issue is not whether or not this property is a farm. The issue is whether or not an agriculturally zoned property is permitted to conduct agricultural uses, and under your code it clearly is. I did want to speak briefly to the point about what the application says and what, how we got here. You heard Ms. Brennan testify that the county planning staff had advised her that she needed to qualify as a farm, and it's our position that that's frankly wrong for all the reasons that we stated, and so that's why the paperwork that she submitted requested to be designated as a farm, and she tried to qualify as a farm, and she was denied. She was told that she couldn't qualify as a farm because her property was not primarily dedicated to agricultural uses, and it's our view, respectfully, that that's just simply not the right interpretation of your code. If you look at the code section that lists the permitted uses, it says crop production and animal production. It doesn't say you have to be a farm. So you can conduct agricultural uses on an AC zone property without having to be a farm. If that were not the case, all the pictures I showed you, single family residence properties, zoned AC or AR, would all have to get rid of their animals. For the record, I would just note, and this is just lawyer talk, but I would object respectfully to any testimony from any neighbors who can't demonstrate that they have legal standing. Historically, I know this body always allows them to testify, so that's fine. But, I would note that this controversy erupted based on a neighbor complaint. And you heard the testimony from the public is essentially about noise, odor, and it's unsightly. They don't like the way it looks. They have complaints about noise and odor. But that, frankly, is no basis under the county code to deny the Brennans a lawful agricultural use of their property. You heard my respected colleague, the attorney for the county, say a few times, I think she actually said that the property was zoned residential. I know she later acknowledged that that's not accurate, that it is in fact zoned AC. But the county's structure, or the county's way of looking at this, is that they view this property as a residential property. And that's frankly a subjective determination. How many houses are close by? That's not what your code says. Your code says this property is zoned AC. It is an agricultural property. There is not a subdivision of this property as recognized by the county. It is legally correct that someone owned this property and subdivided it into different parcels at one time, but there is not a recorded subdivision plan approved by Kent County. So it's not a subdivision under the county code. And it's certainly not a residential subdivision. So you heard a lot of the neighbors say repeatedly things like noise and smell is a problem for residential properties. Well, sure, it would be. You know, if you were in a residential subdivision inside a municipality or inside the growth zone, none of this could happen there. And your code talks about that. The prohibitions are in the context of residential properties. I want to focus on section 20534, which is on the screen. The second provision says no more than 5 such animals. Doesn't say chickens, it says animals. No more than 5 such animals shall be permitted on a residential lot. I would submit to you that that means a residentially zoned lot, and that makes sense. You wouldn't want to have chickens and horses and goats and cows and pigs on residentially zoned properties in Kent County or in a municipality. So look at the pictures in the PowerPoint that I showed you. I think you all have copies of it handy. The chickens at 955 Jeb Road, there's more than 5 chickens in that picture. Remember, it says animals, not chickens, okay? And you can flip through the pictures. Some of them are not perfectly clear, but the property at 633 Foxhole Road, I would submit has more than 5 chickens in it. Same for the property at 91 Tobacco Road. Same for the property at 7921 Willow Grove Road. Look at the property right down the street here, 2140 Jeb Road. The one with all the goats and the sheep. I mean, I'm looking at a picture that shows what looks like a dozen sheep and probably 8 goats at least. So, also, sorry, 929 Alms House Road. There's at least 6 or 7 sheep in that picture. 857 Alms House Road. There's more than 5 animals in that photograph. So the point is that that language, no more than 5 such animals shall be permitted on a residential lot, means a residentially zoned lot. So my client is not in violation of that code provision.
By extension, Mr. Party, you would argue that there's no number limitation.
No,
that's
the only number
that the county can impose on this property in the AC unit, in the AC zone. They can have as many chickens as they want.
That would be our position. Yes, you could certainly limit, and I think that honestly would be the intent, that if you had a residentially zoned property, you could have 5 hens but no roosters. And, it says residential lot. My client's property is not a residential lot. It's true that it has a residence on it because residences are permitted in the AC zoning district, but my client's property is an agriculturally zoned property. You know, this, I said earlier, this is not a subdivision in the eyes of the Kent County Code. It's not a residential subdivision in the general sense either. There's not a common entrance with a entrance sign that has the name of the subdivision. These are individual lots on county roads. So it is a subdivision of land, but it is not a residential subdivision in the eyes of the Kent County Code. And it's the county's PowerPoint, I thought, at least in one place, nailed it when it referred to the comprehensive plan. And it says land uses, agricultural and agricultural-related uses should be the dominant land uses in areas outside the growth zone overlay. You know, I respect these people, and I appreciate that they maybe don't like what's next to them, but they all bought and all live on AC zone properties outside the growth zone in a very rural part of western Kent County. So to say that if you wanted a farm, you should have bought a farm, no. If you wanted to live in a residential subdivision, you should have bought a house in a residential subdivision in the growth zone. You shouldn't have bought an AC zone property in the rural part of Kent County and expected not to ever see any chickens, goats, horses, pigs, and sheep. It's just not the way this state was set up. Agriculture, as I said at the beginning of my presentation, is the most revered industry in Kent County, and what you've seen happen over the years, what causes problems like this, is residential growth infringing on agriculture. And agriculture was here first. If you buy a property in the rural part of Kent County and it's zoned AC, as we talked about earlier, the code requires you to acknowledge that there are nuisances associated with agricultural uses, noise, odor, and so on. So, candidly, while I understand the predicament that some of these people feel, they moved into an agricultural zone. They did not move into a residential subdivision. Again, and I'll wrap up here. The Brennan property does not need to qualify as a farm. Farms are permitted, obviously, in the AC zone, but so is animal production and crop production without being a farm. I should also mention in closing that the Department of Agriculture and DENREC have both visited my client's property, and pending resolution of this dispute, the Department of Agriculture has no problem with the use being conducted on my client's property. It's in compliance with all of their regulations. So in terms of, what you heard about how many animals and how much room there is for the animals, my client complies with all of those regulations. They have, as I mentioned earlier, erected a 6-foot fence around the entire property up to 40 feet from the road on their common boundary with the Hummels. And, an easy solution here, because I think the problem is they don't want to look at it. And my clients are trying to respect that, and that's why they spent over $22,000 in the last week to put up that fence. They are trying their best to do what they're allowed to do and be good neighbors, but maybe planting some trees would be helpful. But I'll end with this. You can't buy an AC zone property on the western side of Kent County and expect it to look, sound, or smell like a residential subdivision in downtown Camden. I'm happy to answer any other questions that you might have.
Yeah, Counselor, maybe you could just go back to this. The application that they presented was to designate their property as a farm. And the appeal, the county said this is not a farm. And the appeal is whether or not the county was correct in their interpretation of the county code, which is what we look at. I'm not seeing the... Could you just...
Sure, no, that's a fair question. We are not a farm. The county's right. We're not a farm. And so the staff's determination that it's not a farm is correct. We agree with that. The problem is that that doesn't end the matter. And in the practice of law, we have something we call conforming the pleadings to the facts. Like you file a complaint and you find out after you file the complaint that the facts are not exactly what you thought they were. That's kind of what's happened here. Is we were told we had to qualify as a farm, and we thought we did, and we disagreed with the county's determination without realizing. My clients, this all happened before they ever came to see me. And so when they came to see me, I said, well, the county's right, you're not a farm, but you don't need to be a farm. So what we're asking the board to do is acknowledge that we don't need to be a farm. I think the solution would be for the board to conclude that the county's determination is correct, it's not a farm, but we don't need to be a farm in order to do what we're doing. That's the resolution that we would ask you to reach.
Thank you.
Sure.
Just real quick, earlier you said that the picture that was presented was not representative of the present appearance of the property. Is that because of the fence? Is that what you wanted to speak to?
Yes, I'm sorry that I wasn't able to produce a copy of what the property looks like right now. My client has a picture of it on their cell phone, but I will represent to the board that it's a 6-foot white fence. I don't think anybody will dispute this. It's a 6-foot white solid fence that starts on the, if you're looking at my client's property from the road, it would be on the left side along the common boundary with their neighbor. And it runs from 40 feet off the street all the way down that common boundary, goes around the backyard, and then comes up the other side as well. And so I think one of the nice ladies even said that, you can't really see over the fence. It's 6 feet tall. And so the neighbors to the immediate left couldn't see over the fence unless they, stood on their tippy toes, perhaps. So that was the genesis of my comment, that the picture does not accurately depict what it looks like today.
So under this notion of conforming the pleadings to the facts, there was some argument that was made with respect to whether building setbacks would apply to a chicken coop. And if this board were to decide in your favor, wouldn't that issue still be hanging out there as to whether or not the structures on the property are
Good question. Good question. No, that has been rectified. So we acknowledge, as I said before, that you can't tell my client that they can't have chickens. You can't tell them that they can only have 5 chickens. But you can tell them that the chicken coops have to comply with the county code. And that's the gist of the Clark case that Judge Graves decided. He said you can't tell people what use they can make, what agricultural use, if their property is owned agriculture, but they do have to comply with everything else about the county code, including setbacks. So my clients have moved the coops, and they do comply with the setback requirement as we stand here tonight.
The pictures that we saw before of the structure right up against the rear boundary line, that structure is no longer
They've been
there, or
moved.
that's not a chicken coop, one or the other.
Okay, so my client corrected me. They are going to be moved on the 22nd. It's my client's understanding, expectation that they're required to comply with that setback, and so they are in fact going to do that. And Donna Brennan just told me.
And they can do that.
Yeah, they can and will. Yes, so they have to comply with setbacks and all other county code requirements. You just can't tell them they can only have 5 chickens.
But they don't have to comply with a restriction on the number of chickens you can have, because in your view,
that provision
that applies to a residential lot and not this property.
That's what it says. Shall not be permitted on a residential lot. And my client, although they have a house on the property, their property is an agricultural property. And let me touch on that just a little bit more, because it was a theme that I heard through my colleague's presentation from the county and some of the public as well. This suggestion that, well, just look at it, just look at an overhead picture. It's a residential area. Okay, well, the houses are all pretty close together, but they're all sitting on AC zone properties. That doesn't make it a residentially zoned property. It's an agriculturally zoned property, and the only criterion that the county can go by is not some subjective notion of, well, how many houses are in the area? Are there is it just one out by itself, or is it 2 or 3 together, or is it 10 or 12 or 20 all in close proximity? I mean, that is just a subjective value judgment, and that is not a basis for making a legal determination Under your code, the question is, what is the zoning of the property? The zoning of the property is AC. It is not residential, and it's not a recorded, recognized residential subdivision from the perspective of the county code.
So half-acre lots, quarter-acre lots in the AC with a house on them and no agricultural uses are agricultural properties.
I'm sorry, could you restate that?
So if you drive around, you find any number of half-acre lots perhaps or smaller in the AC zone with a house on them and no agricultural uses being taken place, those are, in your estimation, agricultural.
Correct. They're zoned agricultural, and just like my client, they could have an agricultural use. Now, obviously, they'd be limited somewhat physically. If the lot's so small, you can't plant a lot of crops and you can't put a lot of animals on it. But conceptually, as a matter of theory, yes, I agree with you that it doesn't really matter how big, except, well, no, see, this, my view is that this section doesn't apply to AC properties at all. But, so, answering your hypothetical, if a property was a half an acre and all it had on it was a house, but it was zoned AC or AR, they could have animals in their backyard if they wanted to.
But that's not a residential property in your estimation. That's an agricultural property.
Yes, that's our.
And they're not, and that property is not restricted in the number of animals it can have.
That correct. That's our view.
Because it's in
that's what the code says. Thank you for your patience, and it's an interesting issue. I don't envy you, but thank you for your time and for listening.
No more public testimony, sorry. Mr. Townsend, do they have a chance to? No, so we're done? All right.
You should declare the public hearing is closed, but that the opportunity for public testimony is passed.
Yeah, right. All right, at this time, this case is closed.
So we will move on to the appeal business meeting. The only application would be application A-25-25 for Donna and Jeffrey Scott Brennan. Again, the present zoning district is AC. The proposed appeal is an appeal of an administrative decision pursuant to section 205-399 regarding the determination that the subject property is not considered a farm under section 205-54 of the Kent County Code.
Thank you. Any discussion or motion?
I do have a question amongst us. Am I reading this correctly if I'm looking at the proposed appeal? I think we're talking about two different things. What's before us tonight under this application is whether or not the county was in error by not considering this a farm. I think that's what the appeal is. That's what we're looking at tonight. A whole nother issue is as to whether or not this backyard flock of 60 birds or whatever it is permitted under the agricultural zoned property. That's two different things, correct? Is that? But they're separate. But we're only looking at one thing tonight. We're looking at whether or not, if it's a farm or not.
The application that was filed, for the appeal that was filed was not on how many of this or how many, what we're what we're deciding is whether or not it's a farm.
Not whether or not it's permitted, whether use is permitted under agricultural conservation. Is that correct?
You heard Mr. Pardee speak to that, and I'm not raising my voice for the purpose of influencing you, but Mr. Pardee's argument is that his client shouldn't have been required to be classified as a farm because we're prohibited from making that classification in the AC district.
The additional discussion?
Well, just for discussion purposes, I'm not a lawyer. I was a sworn clerk in the Federal District Court, but I'm not a lawyer. And however, the zoning may be listed here even on our application as agriculture conservation, but it absolutely lies in what is primarily a residential district with residential uses, and because of if we were back looking at 5 chickens and not selling eggs or something like that, that to me would be a whole different ballgame. But we are looking at one person said there's 60 chickens there. Like, that's even to me more than just a research project. And basically, while I'm empathetic and I for many years was an FFA mother, and my daughter won the national championship for judging beef on the hoof. So I'm familiar with the FFA, and I'm very, I'm proud that you are doing that. I think that's a great thing, and it can lead you to a great future. But that's not the question here. The question here is, does our code find that you can have 60 chickens and the noise, and to me, because I'm primarily my field that I retired from is healthcare, and it doesn't belong in a residential district because of what goes up in the air. Like you can fence in a yard so people can't see it, but it's still there, and there's dust from bird feces. There's many. There's and as I say these, if I were to say like simple names like avian flu, you would get that. But there's things like the virulent Newcastle disease. That's so destructive. Infectious Coriosa. I mean, there's so many things that that belong on a huge piece of property out where it doesn't leach into the soil, to the wells that people drink their water from. And that is why the zoning, like the zoning goes back to a lot more than just because there's not a pretty house there, or who wants chickens in their backyard. At the volume that you have them, to me, it's very destructive from a health point of view to not only you, but to your neighbors, because it leaches. I mean, like, you can't raise them on macadam and anything, and you also can't train them where to go. I know that from growing up on a farm. So I honestly believe that this is not an appropriate, it's
Okay.
not appropriate for us to find this anything other than residential.
May I comment?
Of course.
I don't want this deliberation to sort of meld into what we typically do, which is decide whether we should grant relief from the code in this particular circumstance. This is not an applicant coming to us saying, while the code prohibits us from having this many birds on this lot in this location, we, for whatever reason, should be granted some leniency. That's not what the application is, so our main focus is not going to be on whether this is, or shouldn't be, whether this is a perfect location for that many birds. Our focus has to be on whether or not the administration got it right when they determined that the primary use of this property is residential, and that they have the right to make that determination in the AC district, and then the consequences that flow from making that determination. Or if you look at it as strictly as presented by the county, whether or not this property is a farm, whether it should be designated a farm or whether it should have been denied that designation.
Well, that being said, I feel as though, and I wasn't addressing it as a variance, I'm explaining why my thoughts are, but bottom line is, as far as I'm concerned, it doesn't belong there. It looks like a farm, it probably smells like a farm, and it acts like a farm, and there's not enough room for it to be zoned a farm.
I'll make a motion. I vote to affirm that the Kent County's decision that the parcel is not primary use for agriculture purpose and cannot be classified as a farm under Kent County Code 205-54. I believe the primary use of said parcel is residential and not in farming.
I second that.
Motion and a second.
Thank you. Mr. Carter?
I'll vote in favor of the motion based on testimony.
Thank you. Mr. Gallo?
I vote in favor of the motion based on the testimony presented.
Yep. Can I encourage you to flesh out your thoughts, the two of you, please, and the rest of you as you cast your votes?
In the initial hearing is about the appeal, whether or not the property is a farm, and indications from our observation from the testimony is not a farm, and I don't think the applicant is contesting that. In regards to limiting the number of animals on the property, even in an AC district, the county reserves a right to have conditional uses on an AC property, and I don't think it's unreasonable that they would have conditional uses on the number of animals on a property.
Thank you. Mr. Carter, if you could elaborate farther.
Yeah, based on the discussion and testimony tonight, I think the county probably made the right decision in denying the request.
Thank you. Mr. Jones?
I'm going to vote in favor of the motion. Based on the testimony tonight, I believe that the county did affirm that this is not a farm, and it doesn't qualify to be a farm.
Thank you. Ms. Denny?
Okay, so based on the testimony that we heard here this evening, from both parties, I feel as though the county made the right decision in keeping with the recommendation of the planners, as well as the fact that our code is not a book of suggestions, it's a code, and this really, this designation this property would not fit the designation as a farm.
Thank you. Ms. Hudson?
I vote in favor per my motion.
Thank you. Mr. Cusick?
I vote in favor of the motion that this property use is not a farm. I believe the applicant acknowledged that during the presentation given tonight, and that's what we're here voting on. And even the deed stated that this is a subdivision, so I think it falls within the residential category.
Thank you. That's 6 in favor of the motion.
Thank you. With 6 in favor, application 825-25 is affirmed.
I'll make a motion to adjourn.
Second.
All in favor?
Aye.
Aye.